All right, what's up, everybody? I'm a little late. Sorry, but that's usual, I guess. We got a lot going on as far as like streams and stuff go right now, so I understand a lot of people might not be able to watch this live. That's okay. Um, so this filing, you know, sorry, this filing it came from her attorney's Twitter, Laura's attorney's Twitter. So as always, we take it with like a little grain of salt, but um, generally lately, at least, it's been so that like the filings he posts ahead of time, like ahead of them coming out on the docket, have been consistent. So we're gonna read it, look into it. It is 212 pages, but don't worry because a lot of that is the transcript from the hearing. So we're not gonna read through all of that, right? How's the sound, guys? Is it okay? Okay, cool. Up. 211 pages of insanity. Look, the whole thing is like an obsessive kind of manifesto of like talking about David and Megan. I feel like it is like really obsessive. But we'll get into that. Like, it is a little bit ridiculous. Bronco Fett, they have filed a notice for change of judge, trying to get Judge Mata removed and another judge put on because of like the issue with her father. They go into it a lot and they talk a lot about Dave and Megan's videos and shit like that. And we'll go ahead and read it. It looks like a really long document, but the last like most of it, I feel like towards the end is the transcript, so we don't have to read that. Hey, Goosebump, what's up? All right, I know you guys like me to zoom in a little bit, so we'll do that. Okay. All right, cool. Is it 19 pages long? Well, actually, the ruling is included in the end, so there is the 19-page ruling there. But yeah. Okay. So we haven't seen one of these in a while. Obviously, it's been almost a month, or over a month, I guess, since they filed anything. Um, let's see. We knew that they were going to do this, but we had not seen this yet. So, pursuant to Rule 6.1, Arizona petitioner Laura Owens submits the following notice of change of judge for cause and memorandum and affidavit in support thereof. As explained below, there is clear and convincing evidence demonstrating the judge currently assigned to this matter, Honorable Julie Ann Mata, is biased, prejudiced, and has engaged in conduct which violates both Laura's right to due process of law under both the United States and Arizona constitutions, and which separately violated Rules 2.9a and 2.9c of the Arizona Rules of Judicial Conduct by, inter alia, 1. Performing an independent investigation into the facts of this case. 2. Considering and relying upon information posted on the internet about this case. And 3. Engaging in ex parte communications regarding this case with her father, Harry L. Howe. That poor old man. Like, I don't actually know how old he is, but I'm assuming he's older. That poor man. Like, he just wanted to support his kid, and he's getting dragged into this shit. Hey, class of 83, how's it going? All right. This conduct, while sufficient to warrant additional other relief, including but not limited to a new trial, you do not want to go there, man. establishes grounds to disqualify Judge Mata on the basis of bias and prejudice within the meaning of ARS 12 to 4095. For these reasons, Laura respectfully requests the family court presiding judge, Honorable Rhonda Fisk, review this matter and to find that grounds exist to disqualify Judge Mata and to promptly reassign this matter to a new judge. In the event Judge Mata disputes the allegations set forth below, Laura requests that the family court presiding judge set this matter for an evidentiary hearing pursuant to Family Law Rule 6.1, and that upon doing so, the court approve the issuance of subpoenas ad testificandum. I've never seen that word before, I'm not going to lie to you. To Judge Mata and her father, Mr. Howe. Wow, okay. Okay. So, we're getting very accusatory here right off the bat. I mean, this is not much different than what he's been saying to magazines and shit like that, so... But I was surprised that he made that statement to People, and then I believe People removed the part of the statement where he was, openly criticizing the judge. So I was wondering if he, tried to retract that or what. But, I guess he's standing his ground there. Gosh. Vacation did a number on you, David. Okay. Case summary and background. The facts of this matter are set forth in detail in the affidavit of counsel submitted herewith. In short, this case began as a simple paternity establishment action with one uncommon wrinkle and two non-existent babies. But, okay. Respondent, Clayton Echard, is a minor celebrity as a result of his appearance on the reality TV dating program called The Bachelor. Clayton did not merely appear as a contestant on The Bachelor. He was the star of his season, appearing on the show from January to March 2022. Well, you don't have to flatter the guy. Come on. There's a time and a place. Laura claims she had a one-night sexual encounter with Clayton in Scottsdale on May 20th, 2023, and she learned she was pregnant 11 days later. No. Laura claimed she was raped. And now she's calling it a hookup again. Which one is it, Laura? Which one is it, David? If you're going to call rape, you better stick to it. Laura claims she tested positive for pregnancy on 5 separate occasions. Positive for HCG on 5 separate occasions before this case was filed. May 31st, June 1st, June 19th, July 25th, and August 1st. The first test taken on May 31st was an at-home type pregnancy test. We all know how these pregnancy tests went. She tested positive for HCG repeatedly. We believe that she tested positive for HCG due to reasons other than pregnancy. So we don't need to really go through all that. The fact of the matter is, they will never acknowledge that it was only an HCG test. No matter how many times people point that out, how many times in this document do you think he points out, oh, yes, it was just an HCG test, but she had an ultrasound to confirm? What do you want to bet he's not going to bring that up? Okay. Hey, Zach, what's up? All right. After the parties were unable to reach an agreement on how to deal with the situation, which one, the stalking, the fake babies? Situation's a little vague. And after 2 more positive HCG tests, Laura filed this action. Upon filing and through the present, this matter was assigned to Honorable Julia A. Mata. Okay. So we know all this stuff, guys. Clayton claimed only oral sex. Says the whole thing was made up by Laura. Laura says she had a positive blood test, which again is only testing for HCG. It's not confirmatory of any sort of pregnancy. It did not confirm that she was pregnant. It confirmed that she had HCG in her system. You've had a medical expert explain thoroughly what they do to confirm a pregnancy. So if you want to keep ignoring the facts, that's fine. It's just not really going to get you anywhere. Okay. After learning she was no longer pregnant, Laura filed nothing further in this case, and she took no actions to prosecute the matter any further. Because Laura is not an attorney, she was not familiar with the process for seeking a voluntary dismissal. On December 4th, Court administration issued a notice placing this matter on the inactive calendar and scheduling the matter for dismissal on February 2nd. Okay, so here's a little hiccup. And again, guys, these are my opinions, beliefs, whatever, based on the information we have, and like we've been following this a long time. The thing is, she didn't try to get a voluntary dismissal because she hadn't yet decided that she was going to say that she had a miscarriage at XYZ date. So she was still trying to figure out, in my opinion, when the fake miscarriage was supposed to have happened. Shortly before the case was due to be dismissed for inactivity, Clayton retained counsel Greg Woodnick, who appeared in this matter for the first time on December 12th. Mr. Woodnick immediately filed several pleadings, including a motion to amend Clayton's answer to the petition, and a motion for Rule 26 sanctions. Not this again! Not this again! Notably, Mr. Woodnick filed these pleadings without making any attempt to meet and confer with Laura as required by Family Law, Rule 9, and he moved for Rule 26 sanctions without ever providing written notice to Laura of her right to amend or withdraw her petition as required by Family Law, Rule 26. It has been beaten to death. This horse has been beaten to death, dude. Like, you cannot just, like, go to the court with a knowingly false claim and then just be like, oh, well, you can't do anything about it now because I want to take it back. That's not how that works. Like, he's trying to put this into, like, such simple terms that would work in favor for his, like, client, but that is not how it works. And that is not the only avenue for sanctions. And the only reason I know that is because this man keeps harping on fucking Rule 26 so much. I wouldn't have known anything about Family Law Rule 26. Why would I give a shit, you know? But now, I know more than I ever wanted to. Oh, that's right, the Bachelorette's on right now. Forgot about that. Okay. All right. What's really scandalous about this is that, you know, Greg Woodnick was hired to represent Clayton, and he filed several pleadings as if he were some kind of attorney. Okay. Shortly thereafter, Laura retained counsel Alexis Linval, who appeared on December 22nd and filed a motion to dismiss with prejudice on December 28th. Days later, Ms. Linval withdrew from this matter with Laura's consent. Confusingly, on January 25th, Judge Mata issued an order granting Laura's motion to dismiss. In that ruling, the court indicated, petitioner advises she is no longer pregnant and has filed a motion to dismiss. While the court will grant the motion, the issue of sanctions and attorney's fees remain. Why are you confused? Judge Mata then set an evidentiary hearing on those issues for June 10th. Okay. The undersigned was first retained to represent Laura on March 25th. Who could forget that? After appearing in this case, undersigned counsel quickly discovered that Mr. Woodnick filed a Rule 26 motion for sanctions without first consulting with Laura or her counsel, and the sanctions motion was filed without giving the mandatory 10-day written warning required. I'm not reading any more about Rule fucking 26 because I know that he's twisted it. So I'm sorry, guys, I can't do it. I've heard it all, and it's ridiculous, and it never gets any, you know, smarter. So we're not going to do that. Okay. On May 29th, a minute entry order was issued explaining the court had intended to grant Clayton's request to withdraw his motion for sanctions, but due to a clerical error, happens, the acceptance was not remitted to the parties. Despite the motion for sanctions being withdrawn, and despite no other sanctions or fees motions pending, the case proceeded to trial on June 10th. And on June 17th, filed June 18th, Judge Mata issued an order finding in favor of Clayton as to substantially all issues in the case, and awarding attorney's fees in an amount to be determined by later application. The post-trial order also purported to find Laura lied about being pregnant in this case. She did lie about being pregnant in this case, as well as two other matters. Really? and that she may have committed perjury. There was no may have, sir. Your client lied under oath. If you don't believe me, ask Dr. Higley. Kim, Kayla, did Woodnick file the fees and costs yet? I believe they did, yeah. May have committed perjury is like akin to like minor misstatements and shit like that. Like, this is ridiculous. There is video proof that your client lied under oath. Like, this is fucking stupid. About multiple things. About her ultrasounds, about seeing Dr. Higley. Your client's, she perjured herself. There is no maybe about it. The order's not entirely clear. You know what? Neither is your client's fucking medical history. Based on those findings, Judge Mata referred this matter to the Maricopa County Attorney's Office. Since receiving the post-trial decision, Laura has discovered evidence of extremely serious misconduct by Judge Mata, which is more than sufficient to remove her from this case for cause. Laura will also seek, by separate motion, a new trial and a complete reversal of all prior rulings issued in this case by Judge Mata due to her misconduct, in addition to other relief. What, you want more time for people to pick your lie apart before you go back to court? Like, what is this? This is completely fucking stupid. What the hell? Hey, Brad. Vicinator, he admitted in his own pleadings that she committed perjury and falsified evidence he's obscene. Yeah, right. The way they downplay things is kind of astounding, honestly. Okay. Legal standard. Family Law Rule 6, not 26. A party seeking a change of judge for cause must establish grounds by affidavit as required. Among other reasons, this permits disqualification of a judge by showing the party filing the affidavit has cause to believe and does believe that on account of the bias, prejudice, or interest of the judge, he cannot obtain a fair and impartial trial. Okay. It is important to note this rule does not contain any express time limits for seeking a change of judge, but Arizona courts have read that statute as containing an implicit limit. So now you're cool with implicit stuff. You're cool with a little bit of discretion. Like, now we're cool with that. Am I getting that right? A party cannot ask to disqualify a judge after a trial has begun. Huh? If a judge is allowed to receive evidence which of necessity is to be used and weighed in deciding the ultimate issues, it is too late to disqualify him on the ground of bias and prejudice. Okay. So we want to talk about inappropriate conduct, potential bias. Maybe like what kind of example could you think of? Maybe ex parte communication between your clients and a judge. I hear she has a pen pal in commissioner duty. I mean, you tell me, man. Looks pretty bad. Looks pretty bad. If that's not the case, then, you know, as you always do, I'm sure you'll show us. So, but you got nothing. So, the bloviating is ongoing. Guys, like, the amount of shit that was like surfaced from like the time he came onto the scene here and the day of trial, like, imagine what else is going to come out if they get a new trial. What else is going to happen between now and then? Honestly, like, it's not going to be good for her. And here he is encouraging her to do this anyways. That was an embarrassing showing in that courtroom. Embarrassing. I mean, I've never heard of anyone, like, any, you know, sane person, and like I've said, I believe she's a sane person. She's just like not great. Any sane person like leaning back in their chair, looking at the judge and being like, "That's not fair to have to answer a yes or no question." Like, what if they get a new trial? Can they get more time if there's a new trial? I want to know. Do you think that's going to go well for your client on cross? Do you know how much shit they didn't get into because of the time constraints? Like, it's bad. All right, so we're just talking about change of judge rules here. Okay. Only requires a party seeking a change for judge within 20 days after discovering the basis for the request. The rule expressly provides case, events, or actions taken before that discovery do not waive a party's right to a change of judge for cause. Okay. Because a family court judge may hold multiple trials or evidentiary hearings in the same case over a span of many years, it would make no sense to interpret Rule 6.1 as depriving a party of their right to disqualify a judge for cause simply because that judge held one or more earlier hearings before the grounds for disqualification were discovered. Wasn't it all the hearings? Rather, the text of the rule merely requires a party to raise the issue promptly, even if that occurs after a trial or hearing is completed. As explained in the concurrently filed affidavit of counsel, the grounds upon which a change of judge are requested in this case are primarily based on misconduct committed by Judge Mata, which shows her post-trial ruling, filed June 18th, contained findings that were not based on the evidence admitted at trial. Rather, Judge Mata made findings based on an improper ex parte investigation she conducted, which included reviewing information posted on the internet about this case. Until Judge Mata's post-trial ruling was issued on June 18th, Laura did not know and could not possibly have known of the judge's misconduct in this regard. I mean, they were kind of vaguely hinting that they were going to turn on the judge, in my opinion, long before this. So, I don't buy that. And I don't buy that there was any misconduct either. Megan the Fan Lady Fox. Okay. Mata made findings based on improper ex parte investigation she conducted, which included reviewing information posted on the internet about this case. Until Judge Mata's post-trial ruling was issued, Laura did not know and could not possibly have known of the judge's misconduct in this regard. Although this single issue is sufficient to grant the relief requested, there is also evidence showing other misconduct committed by, committed by Judge Mata, including the fact that she engaged in improper ex parte discussion of the facts of this case with her father, Harry L. Howe. Although Laura and undersigned counsel heard rumors about Mr. Howe appearing at the trial on June 10th, the specific details of exactly what occurred and proof to establish these facts was not fully known until undersigned counsel returned from his pre-planned vacation on June 28th. For those reasons, this request is timely pursuant to Family Law Rule 6.1 because it has been brought within 20 days of discovering the grounds upon which request is based. Discussion. Clear and convincing evidence shows Judge Mata conducted an improper ex parte investigation into the facts. The details of the grounds for disqualification are set forth in the affidavit of counsel submitted herewith. To summarize those grounds, this request is primarily based on the fact that there is clear, irrefutable evidence that Judge Mata conducted an ex parte investigation into the facts of this case, and, even worse, at least one of her post-trial factual findings on a critically important issue was based solely on information posted on the internet and not based on the evidence admitted at trial. Okay. Because episodes of such brazen and blatant judicial misconduct are thankfully rare, comparable examples in Arizona are difficult to find. However, something very similar occurred in Reprimand of Judge B. Carlton Terry Jr., North Carolina Judicial Standards Commission inquiry. Okay, so we're not going to read about that other dude. It's not relevant to us. Okay. Research related to the case, including internet research, is strictly forbidden. Do not do any research or conduct any type of investigation about the case, the facts, the parties, the witnesses, the attorneys, or any person or entity related to the case. Do not look for information on the internet or from any other source about the case or about the facts or issues related to the case. Okay. In other words, do not try to find out information from any source outside this courtroom. The evidence for this, or the reason for this, sorry, is that you must base any decision only on the evidence that is produced here in the courtroom. You must base any decision only on the evidence that is produced here in the courtroom, because the fairness of the trial depends on both parties knowing exactly what evidence you are considering, so that they can respond to it or address it in their arguments. Okay. Notwithstanding all their powers and responsibilities, judges acting as fact finders in a bench trial are subject to exactly the same rule as jurors. A judge may never investigate facts in a matter independently and shall consider only the evidence presented and any facts that may properly be judicially noticed. Okay. God, where is Tiff? Vicinator says those are jury instructions. Yeah, he's saying it's like the same for her as it would be for a jury. Moonshade says, how does Dingus know that Judge Mata did internet research? Was he there? I think he's just going with the wind here. No, I don't think he has any evidence that she looked it up on the internet. I think she's just saying shit. He likes to do that. But if this, Hail Mary pass works and they get a new trial, that actually will be a shit show, because the way that she broke on the stand and wouldn't answer some questions and made up a new story the day of trial, imagine with weeks or months more to uncover all of her credibility issues and really lay out what she's done with the ultrasounds and stuff like that. Dude. Kim Kayla says she gave a damn. Defo Mata was able to review and see her lies. Yes. Okay, so Erica Pauly says, to be fair, we don't know how Mata found out PP was closed Sunday, but I do think she's allowed to look up facts. I don't know about that. Looking up, whatever. Okay, I don't. What I do think happened is, so how she had in her ruling, she had a couple things that were a little bit off. They were more not typos, but just little tiny errors. She put the wrong date on something. And so she, and we'll get into this, he writes it here, wrote in her ruling that I think the expert Dr. Deans or something had said Planned Parenthood isn't open on Sundays, which is when Laura claimed to have gone. Arian Fowler, who is he accusing her of having an ex parte meeting with? Her father. Sorry, that was the actual answer. I'm not joking. Brooke Ward says, didn't the doctor testify about Sunday? So they include the transcript in this document, and it's dozens of pages. So I'm not going to read through all that on stream, but it's in my opinion, it's possible, because we didn't see any of the exhibits or anything like that, right? It's possible that information that Planned Parenthood isn't open on Sundays actually came from somewhere else. In those exhibits, there were a lot of there were blog posts, there were tweets. How many times has this been discussed on Twitter, right? I don't know exactly what they were. We can't see them. So I don't know what was in there. But it's possible that she got the right information and just wrote it from the wrong source, if that makes sense. That's what I think happened, if I had to guess. Okay. So my issue with him is we know that he kind of twists things and doesn't interpret these things correctly a lot. And so this is why I'm like looking at this. I'm like, how bullshit is this? I know there's a little bit of bullshit in here, but how much bullshit is it? Because it's not like he's always totally wrong about law or anything like that, but he does get a lot of things seemingly wrong, like with the Rule 26 stuff. So, and I don't think that's an accident. I think that's on purpose. Like, I think he's just doing the best he can to make an argument. But like, how much of this is real? Okay. Judicial Standards Commission later in public conduct. Yeah. Okay. So I'm gonna after this stream start working on like a standalone post, just summarizing this stuff tomorrow, and I'll try to get through some more of this stuff so that it's like laying out what it means and all that. But we won't get too much into that tonight. Okay. As explained in the affidavit of counsel submitted herewith, there is no question Judge Mata violated this most basic core requirement of fairness. That's a bold statement. No question. Well, can you actually like point to where she got this information? Can you actually like point to like what she did and what she said, who she said it to? Okay. She did so by making a critical factual finding that Planned Parenthood is closed on Sunday, and by falsely attributing that finding to a trial witness, Clayton's medical expert Dr. Deans, who said no such thing. Rather than basing this finding of the evidence admitted at trial, the only possible source of this information was an independent investigation into the facts of this case by the judge, which included looking at social media and or other website comments. It is irrelevant exactly which sites Judge Mata viewed or when she viewed them, because any such ex parte investigation was per se a violation of Laura's right to fundamental fairness. So let's talk about that again, which included looking at social media and or other website comments. However, some of David's tweets and some of David's blogs were in those exhibits. How do I know that other people's comments have made it in there? Because one of mine did. Because in one of these filings, one of my comments on David's blog made it into the court record. So to say like for sure there's no other way other than her doing something devious and just going to like pull information from fucking Twitter. No, like just because you post everything on Twitter and get all your information from Twitter, like that's probably not how the judge is conducting herself. So maybe, just maybe, take a look at your own conduct and what you've been putting out there and what's now been put on the record before making these accusations. That comment of mine, by the way, was me telling someone not to make fun of Laura's looks. It's unnecessary. What they were saying wasn't true, and it was just to be hurtful. And honestly, I don't regret that. I think I stand by that. I think it's unnecessary. But like, you know what? That's just my opinion. But that opinion was there for the public to read, not only on his blog, but in a court filing. Okay, it was there for the judge to read. It was there for the lawyers to read. Anyone involved. So, was there perhaps an instance like this where something was said about Planned Parenthood being closed on Sunday, included in an exhibit, in a filing, somewhere we can't see it right now? But it might be there. I am not going to point the finger at a judge and say she's unethical, because God knows what he's posted on Twitter and how people have responded. Like, I can't keep up with all of it, but I know that this Planned Parenthood thing was an argument over and over and over again. So I feel pretty confident that's probably what happened. That's just my opinion. Like I said, I can't see the exhibits. I don't have any more information than anybody watching this stream as far as like what was in those exhibits. So, but that's what I think. Eric Pauly says, but even we didn't know about the Sunday thing before the trial because the other PP is open on Sundays. I did see people saying that Mission Viejo Planned Parenthoods were closed on Sunday. Those people may have been incorrect. Or they may have like had it partially right, like maybe some were closed on Sundays. I don't know. Honestly, I didn't care enough to look at all the hours of operation for all those facilities. I'm just like going off of the legal documents. So I don't know when it was said the first time, but I guarantee you it was brought up before trial in Twitter posts and stuff like that, because that's when I first heard that. Bruce, I couldn't find Dr. Dean saying PNP is closed on Sunday. Yes, so I looked at the report before the stream. I skimmed it, and then the transcript below, I think it does not have her saying anywhere that they were closed on Sundays. So, true, it is not in Dr. Dean's report. What I'm saying is, I don't believe this is some kind of biased, devious misconduct. I think that it was, actually a misstatement. If I had to guess, she saw it somewhere in all those filings. Somebody was arguing that Planned Parenthood is closed on Sunday, and she got that mixed up. That's my guess. I feel like that's more plausible than Judge Mata is corrupt. I feel like an error in her like sourcing information was probably made. That's what I believe. I believe it was a mistake, not corruption. Ariane Fowler, I refuse to think this judge did anything unethical. I don't buy it. That's what I'm saying. Like, I am not going to jump to the judge is unethical, abusing her power, stuff like that. Like, I'll say it one more time. I believe it was a mistake. Bruce says, sure, a mistake, but from what source? That's what I'm saying. We can't see the exhibits. And there were tons. So, like, the blog posts that have the public's responses on them, right, were in there because my comment was in there on one of the blog posts. So we know that somebody in the public could have responded to his blog, to one of his tweets, and said it. So maybe that's where the idea entered her head. I don't know. That's just my guess. I am not going to sit here and be like the judge is unethical. The judge, like she went out of her way to try to like find a reason for Laura to be guilty. No, I believe that Laura was guilty, and the judge, like I said, made a mistake. So. The transcript is attached to the motion. There's no reference to that. That's correct. So the transcript, you can search the word Sunday in this, and you can see that it was not there. So what he's saying is true in a sense that, like, Dr. Deans did not testify in court that day saying Planned Parenthood was closed on Sunday. What I'm saying is, like, I'm not refuting that. What I'm saying is that I don't believe this was like some malicious, prejudiced, biased thing, and that she was like looking and picking out things on the internet and shit like that to try to find, Laura guilty. I think it was a mistake. Just like I think she wrote June 10th instead of May 20th somewhere in that ruling. Like, there were a lot of little errors in that ruling. So I'm not going to step out and be like, oh my God, this looks so terrible. You know what I mean? Like, yeah, it looks a little concerning, sure. But in my opinion, there's a logical explanation for why that may have happened. And I'm not willing to throw that logic to the wind until someone can prove to me otherwise. So I am on the fence there. So. Pickinator, I believe it was an motion filed by Woodnick. That could be possible. We'll have to go through this stuff. Bruce, I searched the verbal testimony in the report Gingers leaked. Maybe there's something else. That's what we need to know. Well, there are like, so let's look at this, guys. Let's look up what was in the exhibit. So I'm trying to find the document, not the not like videos. A number error is one thing. To add the whole sentence is mysterious. I will explain like a little bit further when I pull this up. But you know what? Hang on. Let me just pull this up. I mean, Bruce and I are buddies. We can disagree on this. That's fine. But I'm still going to try to explain my kind of point of view here. Because to be honest, neither one of us really knows what happened. You know what I mean? None of us do. We weren't there. Neither was David, for that matter. Okay. Can somebody on Discord DM me the document? You know what? I can go to the wiki. Hang on. If it's still on there. God, this is thorough. Okay. Oh, I don't want to print it. Okay. Sorry for the dead air, guys. Give me just a sec. Yeah, I can't find it on here anymore. I don't know if that was like taken off or if I'm just not looking in the right place or what. But Bruce, we're going to talk some more about that. But what I'm saying is, like, I don't think it came from where it obviously didn't come from where she said it came from. I just don't think it came out of thin air. And I don't think it came from the internet. Okay. Let me go on Discord. Need Clayton's pretrial motion document stat. These guys are usually pretty fast. Let me while I'm waiting for a response, which usually takes 2 seconds. I'll try the other Discord too. Never saw Dr. Dean say anything about Sunday in the early doc or the verbal. That's correct. It was not there. And I looked at the report too, and it's not there. So, yeah. All right, cool. Okay. Here we are looking at Clayton's pretrial statement, and I want to go look at the list of exhibits because there's a lot of stuff on there where this information could have been. So let's look at that. Okay. Respondents' exhibits. Let's see. So there's a lot of emails and texts here. Those are mostly, I believe, in the beginning between Laura and Clayton. Okay. Okay. So I did go over the expert report, which is what they have here. And I did not see anything about Sunday closure in there. I do have one other theory, but we'll do this first because I think the other one is also pretty plausible. Okay. Petitioner's deposition. Okay, I don't know if anything possibly could have been said in there. I know they're releasing some of Clayton's deposition clips, but since Greg Woodnick is a professional, they didn't release hers. You know what I mean? And we don't know exactly what she said in there. We know she lied a couple times, but, you know, here it is. Petitioner's counsel's blog posts. Petitioner's counsel's emails and tweets. Do you know how many emails and tweets there probably were? And how many people were tweeting back in those replies saying Planned Parenthood's closed on Sunday or Planned Parenthood, she couldn't have gone that day, anything like that? That is where I think it came from. That's my speculation. My second speculation. The HIPAA releases that were the HIPAA release that was signed and sent to the medical facilities, even though Planned Parenthood didn't have a record of her, they still had to send back something. I believe they had to send back something stating as much. And the paperwork, at least at the hospital I've worked at, the facilities I've worked at, it has the facility information on it. Okay, and I don't know like how many Planned Parenthoods they had checked at, but at my facility, like where I have worked in the past, and I've like faxed a fuck ton of documents related to medical records and stuff like that. You can see the facility hours, the facility contact information, all that jazz, the address, the phone number, everything. Okay, so if it's closed on Sundays, they might have that on their paperwork. I don't know. They might not. Again, this is speculation. So. Or 90, but the PP that responded to the subpoena was from MV, and MV is open on Sundays. Okay, so we'll go back to like the first theory then. In the blogs, in the tweets, I saw people, because this is the first time I heard that. I saw people saying Mission Viejo was closed on Sunday. Those people might have been incorrect, but they still said it. So that still might have made its way into a filing. Like it still might have made its way into an exhibit. So just because it was said doesn't necessarily mean it was true. I'm just saying I think I have enough reason here to believe that in his blog posts and tweets and people's responses to them that were included in these exhibits and other filings, I have enough reason to believe that this was a mistake and not intentional misconduct. So that's my main point here. The problem is the judge needs something submitted saying LAPB is closed on Sundays. I don't know if anyone would have submitted that before trial. So that's what I'm saying. Like nobody had to submit it, right? Because other people's comments made their way into these things. My comment made it into these things. So some random person, like Susie Duty or whoever, Judge Judy's estranged daughter, Susie Duty, may have commented on David's blog or responded to David on Twitter saying that Planned Parenthood is closed on Sunday or Planned Parenthood isn't open on Sunday. I'm saying that's what might have happened to put that seed in her mind. Because look at all this shit, man. Look at all this shit. And look at all the lies that they've had to sift through in like all this kind of shitty back and forth. Like, this is a pretty wild family court case, I think. So, like, I understand how she could have made a mistake. She was incorrect. She was wrong. What she wrote in her ruling, it was factually incorrect. Okay? The hill that I am going to die on is I don't believe that was done with malice. I don't believe it was done with prejudice, bias, intent to try to like hurt Laura. Like, that's what I'm sticking my toes in the ground and I'm standing my ground on. I do not believe this was intentional misconduct. Correct, Bruce. That would be the error. Yes, correct. And that's what I'm saying. Like, I'm not disputing that. It's an error. Obviously, it was wrong. Like what she said, it did not happen. There's no other way around it. Like, you're right. That's what happened. Okay, she got it wrong. My concern is this person like bias, prejudice, or whatever as they claim, or did she make a mistake? I agree the judge didn't have ill intent, maybe just a lack of precision that we require in this case. I can agree with that. It like when I read that ruling, like it was a great ruling, right? The 19-page document with all that she put in there. But there were these little tiny things in there that were just like she lost a little bit of the attention to detail, I felt like, in there a couple times. And I didn't want to like come out and say it like that, you know what I mean? Because why add fuel to the fire when this is already coming? But there were a couple things in there where it's like, oh, that was a mistake, and I'm a little worried about that. But it was a mistake. So like what I'm I guess trying to conclude here is that the judge, while she was wrong, while she was incorrect, I don't believe that she deserves to be smeared or labeled as unethical. I don't believe her professional reputation should forever take a hit. I don't think that she should be known as somebody who's prejudiced, biased, whatever. You know, like I think that she made a mistake, and I think that David is taking advantage of it. That's what I think. Right? That is my opinion. So, and if I'm wrong, then I'm wrong. But how could I know? We can't see it. We can't see the exhibits. What will this do for profiles? I'm going to figure out how to search the blog. Twitter seems like it'd be harder. True. Also, keep in mind, like, people have deleted their accounts entirely. Like, the people, when they interact with him and they get blocked, they make another random account to talk to them. Like, we've seen that happen, I'm pretty sure. Because you'll see, like, somebody with 0 followers who's been on Twitter for one day will be like, hey, I asked you this before and you blocked me. So, like, there's going to be instances where, like, those tweets are no longer there. But they might be in the documented court filings. So. All right. So, with that in mind, let's go back to what we were actually supposed to be talking about here. Hang on. Okay. Didn't find anything on the blog. Not up for searching Twitter, as you say. They may not show up anyways. And let's remember also, like, I don't know if David deletes some comments. He might not. It depends on whether or not it serves a purpose for him, I guess. So I don't know. I don't know if something was on there or not. The only people who know that for sure are the people who can see the exhibits, or the people who could read the comments before and remember that. But, you know, That's not us, unfortunately. But we can keep looking, keep digging into things, see how it goes. All right. Okay. We get it. So you can't do that, is what he's saying. You can't do that. All right. This is a hypothetical number. Oh, God, I love his hypotheticals. You know what? We're getting to one of David's hypotheticals. Is this going to be like Laura's hypothetical about the pregnancy test? Imagine you're a teen. Imagine you're a happy couple wanting a baby. Okay. Hypothetical. In a proceeding, before the judge in a case involving overtime pay, defendant's counsel explains that the plaintiff could not have worked more than 40 hours per week because defendant's restaurant is in the industrial area and only open for breaks and lunch during the work week and not on weekends. The judge is familiar with the area and skeptical of counsel's claims. The judge checks websites like Yelp and Google Maps, which list the restaurant as being open from 7 a.m. to 10 p.m. 7 days each week. Does this search violate Rule 2.9c of the Model Code of Judicial Conduct? Analysis number 1. The search violates Rule 2.9c of the Model Code of Judicial Conduct because the restaurant's hours of operation are key to whether the plaintiff could prevail on a claim of unpaid overtime. The judge should ask the parties and their counsel to provide admissible evidence as to the restaurant's hours of operation. Okay. Because such blatant misconduct is rare, there's no directly controlling comparable Arizona precedent on this issue. Of course, the Code of Judicial Conduct, as adopted by the Arizona Supreme Court, is controlling here. However, courts in other states have consistently agreed this type of judicial misconduct is per se unlawful, and it entitles the movement to automatic relief regardless of whether the error was harmless. Okay, see, this is where, and like, I'll admit, like, just because I don't like that he has a point doesn't mean I refuse to recognize it. So his point here is that it entitles the movement to automatic relief regardless of whether or not it was harmless. So like I was saying before, I believe it was a mistake. It wasn't something that she did to like harm Laura, or it wasn't something she did intentionally. Like, even if it was a small thing, that didn't really change the overall course of the ruling. Like, he's saying that regardless of that, it still entitles her to that relief. I think he has a point there. I don't like it, but I think he has a point. Okay. And I'm not a lawyer, so I'm going to have to check out Omar's thing on replay to see what he had to say about this, but okay. I'm not going to read like this random case history stuff. Okay. This is kind of important. It was the law clerk's duty as much as that of the trial judge to avoid any context outside the record that might affect the outcome of the litigation, and further explaining the law clerk's private view of an accident in litigation was a prohibited ex parte communication that violated Code of Judicial Conduct. All right, so he's still talking about a case in a different state, but okay. Automatic reversal. Okay. Based on this authority, which might not, it might not hold up the way he's trying to put it, Judge Mata must be disqualified on the basis of bias and prejudice, as reflected by her gross misconduct. There's where we're off the beaten path again, in my opinion. Gross misconduct is, I don't know, dude. That's a big accusation to make when you don't actually have any facts about where that came from. There's no question one of the most critical factual findings in this case was the issue of whether Planned Parenthood is closed on Sunday. Actually, that actually wasn't the critical factual finding. The critical factual finding was that she lied in her deposition, said she went to Mission Viejo, and then on the day of trial got up on the stand and lied again, saying she went to LA. The first time she had ever said that. She perjured herself under oath because you and your client know damn well she didn't go to either one of those places, anonymous or not. What? Not at all most critical fact. Nope, I agree. And this is like them trying to say that Judge Judy granting the order of protection based on a fraudulent ultrasound was like not why it was granted. You know what I mean? It's bullshit. Like this was not this was not why she got fucked over. She got fucked over because she lied under oath. She lied in her deposition. She lied in her other hearings. There's lots of video evidence. She changed her story on the day of trial. She refused to answer questions. She refused to answer yes or no questions, said that's not fair. She would not cooperate. The judge said, yes, no, or I don't know. She said, that's not fair. I'm paraphrasing. I think that's almost exactly what happened. But, yeah. Okay. That is actually one of the stupidest things I ever read. The specific reasons why that fact was critical are explained in greater detail in the affidavit of counsel submitted herewith. Actually, I don't need to have these on that. They're hot, so. Okay. God. I'm all sweaty. The over-ear headset kills me. All right. Dr. Deans never testified to this fact, nor did any other witness. True. That's true. I don't think any witness. Yeah, because I don't think Clayton said it. Dr. Deans definitely didn't say it. I know Dr. Medchill didn't fucking say that. So, moreover, on the day of trial, this fact was repeatedly and broadly published on social media sites and by anonymous third-party comments appearing on the personal website of undersigned counsel. There we go, guys. This fact was repeatedly and broadly published on social media sites, aka Twitter, gingerslaw.com blog, by anonymous third-party comments appearing on the personal website of undersigned counsel, David Gingras. So, that being said, it's relevant by his own logic here, his own admission, that these facts or speculations show up on his personal website, on his personal social media sites. So yes, it is entirely possible that it showed up on his website before the trial. Somebody speculated they didn't believe Planned Parenthood was open on Sunday, and that planted the seed. I'm not going to drop my mic because I don't want to buy another one. Couldn't Mata have independent knowledge about LA Planned Parenthood? Maybe. I don't know. I guess we'll find out. Yeah. All right. These facts demonstrate that Judge Mata did exactly what the rules expressly prohibit. She conducted her own independent investigation of the facts and then used the results of that investigation to reach an adverse decision. This is a profound violation of Laura's rights. All right. All of a sudden it matters to Laura. Violations of rights are important to her for some reason. That's interesting. And of the rights of people of of the rights of the people of Maricopa County who trust their disputes will be settled by impartial jurists according to the law. Okay, here we go again. We are bringing everyone into this. It's the you try to scare people to get onto your side type of thing. Try to get in their head. Like, Everyone in Maricopa County should be scared. Their trust might be broken by a corrupt judge. Ooh. That's manipulative. To be impartial, the fact finder must base its conclusion on the facts and evidence and must not reach conclusions based on evidence sought or obtained beyond that adduced in court. When the fact finder violates this principle, the result is structural error requiring automatic reversal. And this is not in the state of Arizona, as we went over before. Okay. So, outside of the Planned Parenthood thing, they're going to harp on this issue with Mata's dad. Okay? Oh my god. He didn't actually write cult-like supporters in a fucking court filing. This guy is an amazing clown. I'm jealous of how good he is at clowning. Like, this is insane. God damn it. I wish I was that good of a troll, man. Alright. Feels weird without these. The hyperbolic speech is so unnecessary, every judge knows cannot do independent research. He loses credibility with that exasperated speech. Brickward, I agree. I agree, but they can't help themselves, right? So this whole this whole thing right here is helping me better understand where Laura got the idea that she could accuse Clayton of fraud for asking her to take a pregnancy test. Like, I'm still dumbfounded by that. All right, but these guys, they're two peas in a pod. So this is insane. Not literally insane, but just this is insane. Okay. The law is clear. A single instance of misconduct by a trial judge is sufficient to establish bias and require disqualification of the judge. As explained above, the evidence proves Judge Mata undertook an independent investigation into the facts, and by doing so, she manifested bias sufficient to require her disqualification. But the evidence of bias and misconduct is not limited to just the Planned Parenthood is closed on Sunday issue. Rather, as explained in the affidavit of counsel submitted herewith, can't wait for that. Another separate issue also establishes Judge Mata's bias. There is evidence showing the judge shared information about this case with her father, Harry L. Howe, and that he not only appeared at the trial as a spectator, he later socialized with Clayton's cult-like supporters, telling them comically, "I'm here for the shit show." So, that is hearsay. That was an embellishment by, I believe, someone who heard it from someone who was near there or around there. That is not the exact quote that came from the father, from what I have, heard from the person who actually said the shit show thing, right? So that's not what happened. Huh. Interesting. Guess it only matters when the judge gets it wrong, right? It is difficult to imagine. I think you meant imagine there. That's fine. We'll let it slide. It's difficult to imagine a more disrespectful, disreputable, and disgraceful act for any judge to commit than inviting her father to attend a high-profile trial in support of a party while also privately engaging in a prohibited ex parte discussion about the case with her father. Oh, man. Oh my god. Dude. Grow the fuck up. This man, a member of the public, a free member of the public, went to a public trial that he heard about because it was a local thing involving a notable public figure. His daughter was the judge on the case. Maybe she didn't fucking invite him, dude. Like, do you think I invited my mom to all my functions when I was younger? No, she just fucking came. Why? Because my parents are supportive. Probably like hers. Don't be a fucking idiot. Jesus. I'm sorry, man. This guy's such a clown. Ugh. He always knows how to cheer me up, though. You just gotta say something real stupid. No, I'm stress eating. Sorry, Bruce. Hey, Meg, what's up? God damn, guys. All right. Whew, calm down. All right. I'm sorry. I'm sorry. Of all the things, I just have to read that again. Oh my god. Okay. Okay. I just had to make sure I got that all right. Okay. Really, dude, really. We just saw a judge in another case. Was it like a young thug or something like that? Who like was engaging in ex parte communication that was actual judicial misconduct. And this man here is like, how dare you invite your father to the circus? How dare you? Not as if he was involved in law somehow and maybe heard about it and coordinated his transportation and appeared on his fucking own. Like Jesus Christ. uh, I've missed these stories, man. I've missed these stories. I was getting a little tired of them for a while, but then I forgot how funny they were. So this is good. All right. These actions made a mockery of these proceedings. These actions, a man, a free man, walking freely into a public space to watch a court hearing open to the public. The justice system is destroyed. He has made a mockery of this court. Why? Because he's her dad. Shut up. As shown in the video clip submitted herewith, Clayton's supporters gleefully celebrated Judge Motta's father's participation in the case. Okay, well, hello. I was the one streaming the case from inside the courtroom. Saw all your hand signals, by the way. Nice one. And I gotta tell you, I didn't know he was there because he was in the overflow room. Couldn't give a shit. So maybe stop generalizing so much, dude. I think that's your problem. That's why you say things like cult-like, and it's like, damn, dude. Like, I like Clayton. I think Clayton's a nice guy. He did a nice thing for me once. I met the guy now, and he was a good dude. Don't care about him enough to be in a cult for him. Like, come on, bro. Really? And your client's not important enough for me to be in a cult to hate her. So, like, honestly, man, just stop flattering your clients. Getting ridiculous. All right. As shown in the video clip submitted herewith. Oh, not this. Okay. Clayton's supporters gleefully celebrated Judge Motta's father's participation in the case, even going so far as to laughingly ask people not to spread information about his participation because, after all, we don't need a mistrial here. Okay. It was a joke, bro. It was a joke. I know he has openly said that he sucks at being funny and comedy or whatever on his Twitter. I can confirm now. You know what? I actually thought that he was kind of funny. He seems like he does have a little bit of a sense of humor when he's not trying to be a super douche defending someone who's obviously lying and terrorizing people. But I don't know. Like, I've always had this little bit, like this little tiny piece of me that's like, oh, he seems like he's smart. Like, he's kind of funny sometimes, whatever. But, if you're going to take something that was clearly said in jest and try to exploit it like this, like, dude, you suck. You suck, man. I don't even think your bad jokes are funny anymore. And I love bad jokes. You asshole, you ruined that for me. Bratty Paralegal, thank you for the 5. Hope you rocked your midterms. We'll be listening to your replay crew tomorrow. Got a few more hours to put in at work. Well, thank you for dropping in, and thank you for the 5. I really appreciate it. Bratty Paralegal, she has interacted with David quite a bit on Twitter. They actually have some pretty good back and forths. She asks like legitimate questions and stuff like that. She's not just like messing with him. So she was on a stream of mine recently, and you might want to go check that out if you haven't already. So what will this do for profiles? I wonder what would happen if I asked ChatGPT to rewrite one of my own briefs in the style of Gingras. Will you please do that? Please do that and report back as soon as possible. All right. Clayton supporters gleefully celebrated Judge Mata's father position in the case, blah, 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 blah. For once, those followers were exactly right. No! A compliment! The conduct of Judge Mata and her father absolutely warrants a mistrial, or more accurately, a retrial before a different unbiased judge. Dude. I have kind of... Okay. Up until now, I have kind of silently maintained the viewpoint that she just wants him to do anything and everything he can and will not let this go. And I don't think that he is just trying to cash in. I think that he's happy to accept the pay, but I think that she's the driving factor, like for wanting a retrial or anything like that. But like reading this, I'm just like, damn, dude. Like I might have been wrong about you. I don't know. Because every time I'm just like, the man's just doing his job. Like he has some not so terrible qualities, because I try to look at that and I try to be fair. And then he does some shit like this. And I'm like, dude, please stop embarrassing me when I try to say you're not a total piece of shit. And then I get mad. And then I call him a twat. And then I feel bad about it later because I don't want to call him names. It just slips out at that point, right? This is exactly what I'm talking about, actually. Arian Fowler, him taking money from a client he knows has lied on the stand and falsified evidence is more unethical than the judge's father being there. Yes, absolutely. Absolutely. And that's why there's just like no excuse. I really like kind of just lost all hope for him being like a decent human being when he did like posted Mike's picture in the podcast and all that. And then with how he treated Mike, I just like, I can't. I can't. Like, you can't make excuses for this person. And then some time goes by and I'm like, oh, he's not so bad. And then he does this. So here we are. Okay. This shameful conduct not only violated Laura's rights, it raises serious questions regarding Judge Mata's fitness as a judge of the Superior Court. Oh, fuck you, bro. Why are you doing this? Stop. Any reasonable objective observer in Laura's position would be justified in wondering. I'm sorry. He just equated Laura's position to like a reasonable objective observer, and like no reasonable objective observer is going to be in Laura's position. Thank you very much. Would be justified in wondering, was my case fairly decided based on the evidence? What? Which evidence? The falsified evidence, or evidence you couldn't come up with when you had to sign a HIPAA release, or... Oh, he did not write that. Or was Judge Mata simply trying to impress her father? Look at me, Daddy. I'm a real judge now. Just watch me destroy a young woman's life because the other party was on The Bachelor. Hee. Oh my God. I can't believe this man actually wrote that. What a fucking moron. Oh my God. This is fucking awful. What the fuck, dude? And I know everything. I know I'm interpreting everything correctly because I just had one drink just now, and I'm like, this is terrible, and it's not even making this like any. Yikes! What is this man's hourly rate to be such a clown? Maybe I should have gone to clown school. Sounds like it pays well, right? You just got to do a couple essays. You know what? I really want to hear Brad read that. I want to hear Brad read that so bad. I hope Brad does his reading. Look at me, Daddy. I'm a real judge now. What kind of fucking lawyer writes that his filing? I love it here. Oh man. I could cry right now. Okay, moving on. Ugh. Assuming the published allegations of Judge Mata are true, that's a big fucking assumption, man. As documented on video by Clayton's own followers. Clayton's own followers don't fucking know Clayton. I mean, I've met the guy and I don't fucking know Clayton. You know what I mean? Like, dude, shut up. Just shut up. That's like saying Beyonce's own followers, if they were, or no, Avril Lavigne's own followers who documented they believe she was twitched by a body double. That's documented evidence because they follow Avril Lavigne. Shut up. Jesus Christ, dude. I need to calm down, dude. Let's have some water. Now, please, let's stay on task here, David. Let's stay on task. Okay. I have to like hide that sentence from my screen, or I'm just gonna crack up the entire time. Okay. And Judge Mata's blatant, pervasive disregard for her ethical duties and her disrespect for Laura's fundamental and her disrespect for Laura's fundamental rights helps explain the judge's numerous and otherwise heretofore inexplicable adverse rulings during this action. You mean she ruled against your client who you wrote about having credibility issues? Who you wrote that she admitted to doctoring evidence? Oh, I love a comedy. This is amazing. Okay. Okay. As a general rule, prejudice or bias is a hostile feeling or spirit of ill will or undue friendship or favoritism towards one of the litigants. Okay. To prove prejudice or bias, an appellant must point to relevant facts other than adverse. Okay, must point to relevant facts other than adverse judicial rulings. Okay. Bias and prejudice necessary to disqualify a judge must arise from an extrajudicial source. In the vast majority of disqualification requests, when the movement argues judicial bias, I'm sorry, I'm just wondering, how much credibility does your client, I mean, I know credibility, but how much less than zero credibility does your client have in making these claims after she said the FBI was investigating Greg Woodnick, a lawyer for the other side in her court case with Greg Gillespie for some sort of weird rape plot? Honestly, man, you can't be serious. And like, you can feign ignorance and say, I don't know what that is, that was before my time, all day long, but there's no fucking way you didn't get curious and read that document. I don't believe you. I don't believe you didn't read. I don't believe you didn't watch the hearings that were before your time. I don't believe you didn't read the documents. I don't believe it. Why? Because it's a fucking mystery novel. Like, Who is this person? How does she keep getting away with this? It's fucking crazy. There's no way you didn't read that. Teresa, your laugh has brought a smile on my face after a very long day. Thank you. Well, thank you, Teresa, but you should thank David. No one makes me laugh like David does. He's just not trying to. All right. You can point to no evidence to support the claim or other than adverse rulings. Okay, so finding no proof of bias where a movement has alleged no facts supporting his claim, the judge was biased, except that the judge consistently ruled against him. The unique facts and circumstances described above make this case one of the exceedingly rare exceptions in which the trial judge manifested clear prejudice and or bias early in the God, this again. In the form of multiple unexplained multiple unexplained adverse rulings described in the affidavit of, oh God, I really don't even want to read that. But unlike 99% of cases, here there is clear extrajudicial evidence showing the true reason for those rulings was, in fact, a hostile feeling or spirit of ill will or undue friendship or favoritism towards one of the litigants. The evidence of Judge Mata's misconduct vis-a-vis her father, discovered only after the trial, supports a finding of bias which does arise from an extrajudicial source, and not merely the adverse rulings themselves, and disqualification may be separately supported on that basis. Okay. So, who was it that talked to Judge Mata's father, David? Since you are so sure for a fact that he said these things and that they communicated inappropriately, name the person that spoke to the father. Okay. I want to see if they have the same retelling of events that you do. What I think you will find interesting is you can name the person who was talked to the father. If they talk to the father, fine. And it's not going to be the same person that you are claiming talked to the father. It's not going to be the follower you are claiming relayed this information. Because you know why? That was a game of fucking telephone. Game over. You know what? We did this last time to make our point, but clearly it didn't get through, so let's do it again. Last time David did this, said that he didn't have any proof, but this is damning that the father said this. We said, or we meaning I, took to Twitter and said, David Gingrich wears wet socks in the courtroom to try to distract other lawyers with the smell of his wet, stinky feet or something. Okay? So that had as much merit as what he was saying in his filing. And, or not his filing even, his fucking blog, right? So, you know what? If he's going to keep spreading this message, we should keep preaching our gospel too, huh? No, it's just, I didn't know a hashtag. Okay, for those of you who are just listening, not watching, we have taken to Twitter again. I heard someone on a live stream say they heard from someone on David Gingras' cruise that he likes to wear the underwear of lawyers he has defeated in trial. Straight from the horse's mouth. Well, the mouth of a horse who knows that horse, who thinks David said something like that. Hashtag logic. Hashtag lawyer misconduct. Anyways, back to our regularly scheduled program. Just needed a little break. Cat lady, you're asking what's the horse's name? Whisper? I don't know, dude. All right. Conclusion. For the reasons stated above, Laura respectfully requests the family court presiding judge, Honorable Rhonda Fisk, review this matter and find that grounds exist to disqualify Judge Mata and to promptly reassign this matter to a new judge. In addition, given the clarity of the evidence and the severity of the misconduct and the harm caused to the judiciary as a result, Laura further requests that the presiding judge refer this matter to the Arizona Commission on Judicial Conduct for further investigation and action as may be appropriate. That is fucking retaliation right there, baby. She got referred to the prosecutor, and so now Laura wants to tell on her. Well, guess what? Judge Mata didn't fake an ultrasound, bitch. Sorry, you know how some people say something and they say bitch afterwards? It's not like, I'm not calling anyone specific a bitch. I was just like being a tool. You're not a bitch, David. You're a douche, but you're not a bitch. I'm scared to read this. I'm not sure my heart can take it, dude. All right. Affidavit of David S. Gingras in support of petitioner's notice of change of judge of cause. I, David S. Gingras, hereby swear and affirm under penalty of perjury as follows. 1. My name is David S. Gingras. I mean, I don't care about that, bro. I don't care. I'm an attorney. Sure, I guess. Okay, blah, 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 blah. As explained below, I have cause to believe, and on these grounds I do believe, that on account of bias, prejudice, or other interest, the judge currently assigned to this matter... Sorry, I just got a text back. Honorable Julie A. Mata is unable to act fairly and impartially, and is unable to provide petitioner Laura or Miss Owens, with a fair trial, including a fair retrial, which Miss Owens is concurrently requesting. For these reasons, Laura requests that the family court presiding judge, Honorable Rhonda Fisk. Okay, Honorable Rhonda Fisk, please do something, please, so I can stop reading your name. Just kidding. Tell them to fuck off. Immediately reassigned to new judge, blah, 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 blah. We get it. We get it. You're mad. You're mad. We get it. Okay. We don't need the case summary and procedural background. We all know what happened there for the millionth fucking time. All right. Here's the more interesting stuff, guys. Oh my God, it's been an hour and a half already, man. This is crazy. Okay. Despite being an otherwise simple and short-lived paternity matter, this case quickly gained local, national, and even international media attention and massive public scrutiny. There appear to be two main reasons for this. First, Clayton is arguably famous as a result of his recent appearance on a nationally televised reality TV dating program called The Bachelor. Okay, let's not downplay that you called him the star earlier on in this filing. Okay? This media attention is relevant and important to understanding the basis for this notice, because it appears the trial judge, Julie Mata, allowed the significant media hype and public attention to overwhelm her better judgment. Oh my God, you douchebag. Eventually causing her to engage in conduct which violated Laura's right to due process, including her right to have this matter heard by a fair and impartial jurist. Because that issue is key to understanding what happened here and the grounds for disqualifications raised by Laura, this subject is discussed in some detail below. So, let's talk about what we're not mentioning here. What we're not mentioning here is that Laura brought this to the media. Laura went to Reddit because she wanted the public to know about it. Clayton wouldn't have said a goddamn word. Okay? So the widespread attention this case has received is because your client spread it. Do not get that twisted. All right. This media attention is relevant and important to understanding the basis for this notice because it appears the trial judge, Julie Mata, allowed the significant media hype and public attention to overwhelm her better judgment. Okay, we read this already. It's just, sorry, it didn't register the first time because it's so stupid. Because that issue is key to understanding what happened here and the grounds for disqualification raised by Laura, the subject is discussed in some detail below. Some detail. Some detail. I'm sure there's some details there. I'm sure. For anyone who is not familiar with the show, The Bachelor is a long-running reality TV dating show that first aired on ABC in 2002. I heard your client applied a couple of times. Huh. Yeah. The show involves a single male star, the titular bachelor, who is presented with a number of female contestants, usually around 25, from which to choose a potential fiancé. In addition to The Bachelor, involving a single male lead, the show has several spin-off series, including The Bachelorette. Why do I care about that right now? This is a fucking court document, sir. This is not Twitter. Get to the point. Over the course of a season, The Bachelor goes on... Why the fuck are you writing about this? Why are you showing Clayton with puppies? It's like you're in a fight against yourself here. Have you been bored on vacation? What are you doing? What are you doing? I'm not reading that. I'm not reading that, stupid. All right. This leads to the second aspect of this case, which caused it to gain far more media and public attention than normal. Your client going to all the press. Fuck that. Okay. The Bachelor, Clayton has a large and highly devoted fan base, including many followers on social media. For example, Clayton currently has nearly 300,000 followers on Instagram. Okay. Thanks for the ego boost, I'm sure he's thinking. These facts, Clayton's fame, and the huge pop... Okay, so before he was a minor celebrity, and now it's Clayton's fame and the huge popularity of The Bachelor. Make up your mind. Okay. Coupled with the extremely odd allegations in this case, i.e. that Laura fakes being pregnant with Clayton. Well, Laura did fake being pregnant with Clayton. That is factually correct. Have caused this otherwise simple... I mean, it's odd, don't get me wrong. Odd allegations, but it's odd, but true, right? Crazier things have happened. But, you know, unfortunately, most people who do those crazier things get punished. So, maybe it's time to think about jail. All right. Have caused this otherwise simple case to gain a massive amount of public scrutiny and attention from local, national, and international news media. Your client said she was having the Bachelor's babies, and she fucking lied about it. That's why it got a massive amount of attention. Jesus Christ. That is so stupid, man. That is so stupid. In addition to being widely covered... Oh, no. I guess he just wants to say hi to everyone. All right. In addition to being widely covered by traditional news outlets, this case has also received massive attention on social media, including sites like Reddit. Your client posted everything to Reddit. She posted a fucking Dropbox to Reddit with messages, fake evidence, all kinds of shit. All right? Let's not get it twisted. Your words are not going to distract me from the fact that your client brought this to the public. Jesus. For instance, anonymous fans of Clayton have created social media pages focused entirely on this case, including a Twitter account using the hubristic suffragette Justice for Clayton, or JFC. The JFC Twitter account has posted obsessively about this case nearly 3,500 times. One example of which is shown below. Well, sir, I don't think you should be calling anyone obsessive. Okay? The way that David Gingras has tweeted and blogged about this case, that's not a part of his job. He's a fucking lawyer, not a gossip columnist. All right? This man is trying to distract you by saying you're obsessed or whatever, trying to make you feel bad about it. But let's not pretend for 1 second that he isn't just as obsessive, just as seething about this as anybody else. Because this man cannot stop. He keeps saying, I'm not going to post anymore. I'm not going to tweet anymore, whatever. And he keeps fucking doing it, even on his vacation. Why? Because he is just as obsessed as anyone. And honestly, interest is not obsession. So really, stop your drama, okay? Public interest is not public obsession. And why does the public have all these details? Because your client put them out into the universe. Nobody asked for that, all right? Nobody asked to hear about your client's tight-ass vagina, right? Nobody asked for that. And yet, we all had to hear it. Thank you. Hey, Chris, what's up? Candace Flox, thank you for the two. Two previous lawyers withdrew because of lack of candor. Yep. Well, there was Corey and there's Lexi, so. But goddamn, dude. I needed a breather. His little document here is like the worst part of this whole thing. It's just because like every single sentence, and I know it's like trying to elicit a reaction, but like I'm human. Of course, I'm gonna have those reactions. If you say something stupid, I'm gonna gawk at it. I might laugh at it. All right, I don't know. I'm a human being. If you put a train wreck in front of my face like this, I'm going to be like, oh my God, look at the train wreck. You know what I mean? It's not an obsession. It's a, look at the fucking train wreck right in front of my face that you keep putting there. You keep putting your train wreck in front of my face. Okay? This goes back to like the dump on a park bench theory, right? You keep taking a dump on a park bench right in front of my face, except your dump is a court filing and the park bench is the Maricopa County Court. I can't just like not notice that if I'm walking along minding my business and then all of a sudden you're taking a shit on a bench right in front of me. Hello. Gosh, wish I could pretend that didn't happen, but it did. So yeah, put your shit in front of my face. Put your shit in front of the public's face. They're going to react to it. You don't like it? Stop doing it. Because you know why? You posted this on Twitter, David. Laura posts her tweets, her blogs, whatever, and David posts his filings on Twitter because he likes it. He likes us to talk about it, and that's fine. That's fine, but let's be honest. Let's be honest. Let's not call anyone obsessive when he's so desperately craving the attention and the reactions that he has to post them on Twitter before they come out on the official docket. He needs it. He wants it so bad. Don't call people cult-like. Don't call people obsessed. You are the same level of invested here. International news media. Girl, you're not that special. Girl. No, girl. In addition to being widely covered by traditional, blah, 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 Twitter, heaven forbid, a Twitter account post tweets. This has been going on for almost a year. Get the fuck over it. Do you know how many times you've tweeted? I don't, because I had to block your Twitter account, you asshole. In addition to posts on Twitter, anonymous fans of Clayton have created websites devoted solely to this case and to promoting their belief that Clayton is somehow a victim who deserves justice. You do not want to fight us on this one. Oh, no. One such pro-Clayton fan site is justiceforclayton.com, which contains copies of all or substantially all pleadings filed in this case. The site also contains a one-sided narrative which highlights only those facts favorable to Clayton's version of events, while carefully avoiding any discussion of facts unfavorable to Clayton's narrative. What facts unfavorable to Clayton's narrative? You know? What? Let's see here, David. Which contains copies of all or substantially all pleadings filed in this case. All or substantially all. Oh, I get it. So Laura's attorney didn't file any pleadings in this case? Nobody's looking at their file. Oh, wait, that's right. You're fucking bombarding us with stupid ass filings all the time. What are you talking about? Your narrative is all over the place. It's like you took a shit on that park bench and now you're using your shitty narrative to wipe your ass in public. That is not a one-sided narrative, sir. I'm here reading your words. Because your words are stupid and don't make sense and don't add up and omit the truth. Okay? That doesn't mean that I'm not covering your side. All right? I'm covering your side. I'm reading it. It's just hilarious. I can't help it. Erica Pauly, how can you post all court filings and also only post one-sided stuff? Exactly. Also, he uploaded this exactly when he knew Dave was going to go live, so Dave would talk about it. Was Dave planning to go live before that? I didn't know. The last 2 weeks, guys, I had midterms. I had my regular full-time job during the week, and then I worked yesterday. I worked 8 to 8 at the hospital, so I've just been too busy. I didn't know Dave was streaming tonight before that. I saw when I came on to do my thing, I saw that he had a stream going, but I didn't know about it ahead of time, and I didn't get a notification, so yeah. But no, that's not surprising because when Mike Maricini's interview with Megan Fox, when she was doing that, he posted his blog post at the same exact time. It's not an accident. That's intentional. So. In addition to social media posts from his fans, Clayton himself has been extremely personally active in publicly promoting this case, giving countless media interviews in which I mean, you can probably count them, bro. Probably count them on your fingers. Dude, really? If you can't count them, you're stupid. Come on, dude. You can count to 10. Clayton's attorney, Mr. Woodnick, has also published statements regarding this case, including a press release issued on March 7th, in which Mr. Woodnick accused Laura of fraud. Well, Laura committed fraud, suggesting she has been accused of fabricating pregnancies and doctoring medical evidence as a means to extort relationships several times dating back 10 years. Where's the lie? She has been accused of those things. Where's the lie? Are you upset because Mr. Woodnick exercised his right to state the facts on behalf of his client? What about that is upsetting to you? That it hurts your case? At least be honest about it. And in an attempt... Oh, no, he didn't actually link to his stuff. This court filing is like the weirdest self-promo I've ever seen, bro. In an attempt to respond to... Oh, no. You like it. Don't even pretend that you were trying to respond to a one-sided narrative. You like it. Acting at Laura's request by... Well, that's a shock to no one. And with her written permission, guys. I've said this. I don't know if I said it on stream, but I've said this a couple times. I'm like, I don't think that he's doing this without her putting that in writing because of what happened with the other lawyers. So, like I said, he's smart. He's a smart guy. He's not like, I'll say like you're stupid or whatever because I think that what he's saying, the argument he's making, I think it's stupid, but he's not a stupid guy. Like, he's a smart guy. So, yeah, like he knows what he's doing and what he needs to do to protect himself, especially because I don't think he has malpractice insurance. If I'm wrong on that, let me know. The purpose of these comments has been primarily, if not exclusively, to respond to information being circulated about this case by Clayton, his lawyers, and or his fans/supporters. Okay. So, How did posting a picture of Michael Maricini or a podcast, a random ass podcast Michael Maricini did with Laura years and years ago, how is that in response to information being circulated? What point did that podcast prove? What did they talk about in that podcast that was relevant to this case? Now, what I do believe is that it was Laura's request for him to post the picture. Why? Because Mike Maricini did not, by her own kind of admission, I think, I believe she said this before, did not want to share pictures of them together and be all coupley when he wasn't sure he wanted to be in a full-blown relationship with her. So how did she get back at him, finding out that he might be involved here? Well, she had her lawyer post that picture. That's my opinion. When I post comments on either Twitter or my personal website, members of the public can and often do post responses, comments, replies. This point is important for reasons I will describe further below. Oh, God. He's so obsessed with Dave. He's so obsessed with Dave. This is giving tag. It's giving tag, guys. Rogue Mama, what's up? Okay. Oh, he pre-scheduled to talk about Jen. I got you. Okay. All right. Before discussing the specific issues and conduct giving rise to Laura's request to disqualify Judge Mata, have we not talked about that yet? Because, oh my God. It is important to understand some of the other participants who will be mentioned further below. Two such participants are individuals named Dave Neal and Megan Fox. I do not personally know either Dave Neal or Megan Fox, and yet you bore your fucking soul to him in a novel of an email. But okay. But during the course of this proceeding, I've become generally familiar with them. You're such an asshole. You're obsessed with these people. According to his YouTube channel, Dave Neal is a stand-up... If I were Dave Neal right now, I'd be looking at this and be like, hey, SpawnCon. Dave Neal is a stand-up comedian who lives in Tennessee. I bet you know his address, you creepy motherfucker. Dave also creates and publishes videos on YouTube nearly every day. Wow, it's almost as if that's his fucking job. Dave's videos often focus on The Bachelor and people like Clayton who have appeared on that show. I'm sorry, I'm trying to get to the point here. What was the point of that? David Gingras is a lawyer representing Laura Owens. Like, hello, we can state the facts about people's jobs all day long. What do you want? What do you want from us? Fuck off. Over the last several months, Dave Neal has obsessively published hundreds of hours of videos regarding this case. Again, often on a daily basis, as reflected on his YouTube channel below. These videos are generally, almost universally, devoted to viciously attacking Laura, and often me, and to proclaiming that Clayton is a victim who deserves justice. That is hilarious. I'm sorry. Devoted to viciously attacking. Like, Dave's been very tame. Dave has been very tame about this, man. Like, he didn't share that weird, shitty email that he could have blasted all over the internet at first until, like, much, much, much later on when it was, like, too far gone. When it was like, well, there's no point in not sharing it now. So, honestly, dude. Dave has not, in fact, viciously attacked Laura or you. He would not say her name until, was it the day of court? Was it after court? I don't even know, dude. I don't even know. But my God, man. Pointing out the truth and pointing out what your client has actually done is not a vicious attack. It's a recap of factual information. A biography, if you will. Notably, Clayton has personally appeared in several of Dave... What? What the fuck are you talking about? He did like a drive-in with Dave or something, and now all of a sudden they're like butt buddies? Shut up. Shut up. Clayton has personally appeared in several of Dave Neal's videos, and it is clear that Dave Neal is not covering this case as a neutral journalist, but rather as a passionate, obsessive advocate for Clayton. You know what, man? If I were in Clayton's position, or if I could go back to my younger years when I had someone manipulating me, I would wish to God that somebody was obsessive the way Dave Neal is. Because, dude, seriously, like, I wouldn't have known about any of this stuff, right? Like, we would know what Laura posted on Reddit, but I wouldn't have known about any of this stuff that happened afterwards or what came out and all that. I've always liked Clayton. I'm not like a fangirl. I don't even watch The Bachelor, Bachelorette anymore, really. I watched this season, but I'm not like a big obsessive Bachelor fan. Like, just because somebody has a different opinion than you, just because somebody's on the other side of the line, doesn't mean they're obsessive. Obsessive would be something like seeing a TikTok you didn't like and calling a sheriff's office across the country on somebody because you didn't like what they said. That's obsessive. Obsessive is tracking down my friend's employer somehow, even though her real name, I don't think her real name was on that Twitter account. Tracking down my friend's employer, even if it was, it's fucking creepy. And then calling my friend an obsessive stalker while tagging her employer in the tweet. That's obsessive, all right? Sending over 500 emails, that's obsessive. Texting from 13 different phone numbers, that's obsessive. You know what's not obsessive? Caring. You can care about the truth. We can talk about these things. You can be interested without being obsessed. Not everyone has to fake a baby to stay involved with something. Get over yourself. All right. Another YouTuber following this shut up, is an individual using the name Megan Fox. That's her fucking name, you know what? I do not personally know Miss Fox. I believe that name may be a pseudonym. But she has contacted me via email several times during the case, and I understand she claims to be a journalist who publishes stories on extreme far right-wing news websites. Okay, no matter what your politics are, a journalist is a journalist. Like, if a journalist writes something that you don't like, it doesn't make them less of a journalist. It just means you don't like their stories. You don't like their work. Boo-hoo. I don't like your work as a lawyer. I think you're scummy and you tell a lot of half-truths. That doesn't make you any less of a lawyer. So maybe keep that in mind next time you're insulting someone's job title. Like Dave Neal, Megan Fox also creates and publishes videos on her YouTube channel here. Stop advertising for people, David. My gosh, you're so nice. Like Dave Neal, Megan Fox is a passionate supporter of the JFC cause, and her videos are overwhelmingly devoted to exposing and destroying Laura. Okay, well, if exposing your client's actions is destroying her, it's because she's done terrible things. While promoting the narrative that Clayton is an innocent victim who deserves justice. Well, that narrative is actually based on a true story. So, Dave Neal and Megan Fox are mentioned because you're obsessed with them, because they are relevant to the issues raised herein. This is so because they attended the trial. Who fucking cares, dude? They both attended the trial held in this matter on June 10th, and after the trial, both appeared on video claiming to have, or speaking with others who claim to have, direct knowledge regarding certain improper conduct committed by Judge Mata during the trial. Actually, no, I don't think anybody said anything about improper conduct by Judge Mata. So, are we just bending the truth a little now, or? Okay. Including the fact that Judge Mata allegedly engaged in improper ex parte discussions about this case with her father, Harry L. Howe, who also personally attended the trial and socialized with members of the JSC group. Those points are explained further below. Okay, so before we read on, Judge Mata's father is an independent adult man. He went to a court hearing that was open to the public in a public courthouse. Everyone there qualifies for your definition of the JFC group. No one was there to support your client. Why? Because she lied. because your client is a fraud, because your client perjured herself, because she is not telling the truth. So, why then should Judge Mata's father have to not greet the people around him? Like, it's just polite to make conversation with the people around you. Like, why should he not? Like, he's excited to see this. It's a court case that he's been interested in. It's a local thing with a what you call it, a minor celebrity with a very special superstar bachelor, which, you're really contradicting yourself there. Okay, so why then is he not allowed to speak? Because I thought you were a free speech lawyer. And if you think he has the right to speak, he has to speak to someone, right? Because he's not just monologuing in there. He has to speak to someone. And assuming that no one was there for your client, because they weren't, those people would therefore, by your definition, be members of the JFC group. Which I guess your broad definition of that is anyone who knows that Laura lied. So, yes, that man sat down. He was probably, you know what probably happened? The man sat down in the overflow room. He was perfectly polite and respectful. He briefly chatted with people around him as like friendly social people do in normal public settings. And somebody got excited about that and they relate it to a friend. And you know how we tend to exaggerate things when we're excited and we're just talking to friends. So something got passed, and what ended up coming out is not at all what that man said. So, I don't know, man. This is pretty pathetic. Personally attended the trial and socialized with members of the JFC group. You know what? You personally socialize with members of the JFC group all the fucking time. On your Twitter account, on your blog account. You gonna refute that? Summary of pre-trial judicial bias. Fuck off. God damn it. Candace Fox, I'm a very progressive lefty, and I appreciate and admire Megan Fox's journalism. Yeah, so like I don't really care like if I disagree with someone on political stuff. It's not gonna like form an opinion. Like it's not gonna affect my opinion of them as like a journalist or a teacher or whatever. So yeah. Teresa says Obsessive is trying to serve Clayton at a girl's house he mentioned on a podcast once and had never met. Very much so. Very much so. All right. Let me fix this here, guys, but I'll keep reading. Give me 1 sec. All right. Shortly after I became involved in this case in late March 2024, several events occurred which initially caused concern regarding Judge Mata's possible bias and lack of neutrality. Specifically, immediately after Laura retained me to represent her in this matter, I attempted to obtain a copy of her file from her previous counsel. Wait, which one? Didn't she go through a few lawyers? Okay. Unfortunately, Laura's prior counsel did not promptly respond to this request. This made it impossible for me to respond to a motion to compel filed by Clayton before I was retained. The response to the motion to compel was due mere days after I was retained. Because I could not respond to the motion to compel without a complete copy of Laura's file. Well, didn't he write the motion or his response to the motion to compel with like some weird references to Donald Trump or something? Like, I don't think you needed Laura's file for that, bro. But okay. And because Mr. Woodnick refused to agree to an extension of time, well, she was on her third or fourth lawyer, right? I mean, guys, was so she had the guy in the order of protection hearing, right? And then there was, I think, another lady when she started on this case, but that lady never filed anything. Was that right? Bonnie Platter. So yeah, I think she had, was it 4 in this case? Somebody let me know. Oops, I did not mean to mute myself. Okay, so at least 3, right? The motion explained the request was primarily based on the fact that I did not have a complete copy of Laura's file because her previous counsel did not properly provide the file to me. Okay. He's so mad about this, man. Despite the fact good cause existed for my request for an extension, and despite the fact Mr. Woodnick did not oppose to the motion, just days later on April 3rd, 2024, Judge Mata issued a one-sentence minute entry order denying my extension request without any explanation. What? As a lawyer who has practiced exclusively civil litigation for more than 20 years, it is extremely unusual, essentially unheard of, in my experience, for a judge to deny an unopposed request for a short extension of time regarding a simple discovery matter when good cause clearly exists for the request, when no prior extension request had been made, and when the other party would not be prejudiced by the request. In fact, having litigated hundreds of matters in state and federal court over the course of my career, I cannot recall a single prior instance where a similar request was denied. Well, didn't she not show up for her deposition? I feel like we're leaving out some important stuff here, dude. Okay. Of course, I am also well aware that as a matter of law, adverse judicial rulings alone do not support a finding of bias or partiality without a showing of an extrajudicial source of bias or a deep-seated favoritism. Stagecoach trials. Stagecoach! I don't think it's the same Stagecoach. For that reason, I determined that although the Judge Mata's unexplained and apparently baseless denial of my extension request raised concerns about possible bias, the adverse ruling standing alone could not support a finding of bias. As such, I took no action at that time. Shortly thereafter, I discovered that in the motion to compel, Clayton's counsel, Mr. Woodnick, made multiple statements to the court which appeared to be knowingly false. Oh god, not this again. This is about the hand size shit. After I confronted Mr. Woodnick with these concerns, he refused to speak to me by telephone for several weeks because you were being a psycho, man. God. Given the fact I was newly retained and not familiar with the complicated history of this case, Mr. Woodnick's refusal to speak with me made it much more difficult to prepare this matter for trial. Dude, come on, man. Like, you don't need him to... Okay. I mean, I don't think it was Mr. Woodnick's fault that you said in trial that you didn't understand what they were talking about at one point because it was before your time. I mean, you can't tell me you didn't have the complete file by then, bro. Come on. Come on. All right. I think this is as good as it gets, guys. So I'm just going to put my camera back on. Hold on. There we go. Okay. Looks like a weird... Whatever. It is what it is. Okay. I have headphone hair. Candace Fox says, yes, she skipped first deposition and failed to sign medical releases. Yeah. Okay. For that reason, oh God. I try to forget about this. For that reason, I filed a motion entitled Motion to Compel Lunch and for Alternative Relief. In that motion, I informed the court that Mr. Woodnick was refusing to speak to me by phone, despite multiple rules of procedure and professional conduct which required counsel to meet and confer by phone. As a result, I asked the court to order Mr. Woodnick to speak with me, in addition to other alternative relief. Dude, you're leaving out a lot of stuff here. All right. To support that request, my motion cited an earlier... I don't care about that, bro. Your motion was still insane. Unfortunately, as she did with my request for an extension of time to respond to the motion to compel, Judge Mata issued a single-sentence minute entry order denying my motion to compel lunch. Because that's a fucking weird thing to file. The order denied my request without any analysis or explanation. Well, sir, not everyone needs like a long-ass document to say no. Later that same day, I learned for the first time that Clayton's counsel intended to use previously undisclosed evidence and witnesses at trial. Due to the untimely and extremely late disclosure within an hour of this discovery, I filed an emergency motion bringing the issue to the court's attention, and I requested an immediate scheduling conference to discuss the issue further. Okay, but this was timely. Like this all happened before the deadline. So again, like it's weird. Like his client, it was fine when his client was refusing disclosure, right? But they are giving him the disclosure like well before the deadline, and he's freaking out about it. Like, despite the fact Rule 76.1 provides the court must order a scheduling conference when requested, on May 22nd, Judge Mata issued a minute entry order denying my request. Didn't they already have a conference before he came on board, like shortly before he came on board? I'm pretty sure that happened already. Yikes. Taken together, Judge Mata's single sentence, zero explanation denial of these three motions. One, the request for oh god, I'm not even reading all that. The motion for extension, motion to compel lunch, requiring Mr. Wood to speak with me, requesting a scheduling conference. However, I continue to believe that despite the existence of what appeared to be apparent bias and hostility, Judge Mata's adverse rulings alone would not support a finding of bias sufficient to seek her disqualification because of the rule. Okay. Summary of judicial misconduct and bias at trial. This matter proceeded to a bench trial before Judge Mata. Prior to trial, I learned that Dave Neal and Megan Fox, among other JFC supporters, like, you sound like a conspiracy theorist, man. Come on. These are all private citizens, but they have a right to attend a public trial. So maybe stop lumping them all into one person. Like, there are people from all over the place who were interested in this story, the story that your client put out into the media, and decided to come and see the trial. All right? It's not some weird random cult. Right? It's not like your client accidentally walked into this shit show. Like, your client created the shit show. And when bystanders are curious about it, you don't get to then be like, oh my god, they're all terrible people. Ugh. Because they're giving your client the attention she asked for, the attention she wanted. The only problem is they found the holes in her story. Okay. It is my personal belief that courts are publicly funded for trials and legal proceedings belonging to the public and should always remain open. So, like, what is your problem, bro? I further believe, as a matter of law, that members of the public have a near absolute right to observe and report on events which take place in court. So I viewed the public interest in attending and observing the trial as a good thing. Well, whether you thought it was a good thing or a bad thing, it's still, the public still had a right to be there. So your view or your opinion is irrelevant. Sorry. Not sorry. However, when I arrived to court on the morning of trial, I was surprised to see dozens, if not hundreds, of people waiting to watch the trial. Okay. As somebody that was sitting in that same little room with David Gingras, that's not fucking true. All right? There might have been, a few dozen, maybe a little bit more than that. There were not hundreds of people there. That's ridiculous. Before trial began, Judge Mata spoke to counsel in her chambers and informed us that she had created an overflow room for at least 50 observers to watch a trial, and the seating in the courtroom itself was packed with spectators. So, also not true, because I was on the left side, behind David's back to the left, had the streaming camera, and Scott and I, who were operating the stream, had a lot of space to our left, and that's the reason we were able to set up the camera, and there was a lot of space to our left behind in the row. So it wasn't packed, right? And also, they only allowed a certain number of people into that room. And again, you just said you believe the public have an absolute right to observe these things. So what, again, I'll ask, is your problem, sir? Judge Mata informed counsel that she had taken certain security precautions due to the large crowd of spectators. Okay. Are you opposed to that? What? I found Judge Mata's comments about the crowd surprising because prior to the morning of trial, there was nothing filed in this matter. Aside from a small number of media requests for filming, that was me. Hello. One person. And then Megan had her camera person, and Megan was tweeting, but hi. That would suggest such a large crowd was likely to attend. No, I don't buy it. I don't buy for 1 second that she... No, you know what? Because your client has been posting tweets from Dave's Discord all over fucking Medium posts. So she knew exactly how many people were going to be there because she stalks that Discord like a freak. Like, she can't stop. Right? Even though she says it depresses her so much, she will not stop. She knows everything that everyone says. She takes screenshots. She knows what random ass people are doing and who they work for. Okay? So no, I don't buy for 1 second that your client or you didn't know that many people were going to show up. That's a lie. You're lying. There was about 40, and apparently half were undercover police. Yeah. So in the courtroom, the actual courtroom, there was less than that. So. Okay. Based on this, it appeared Judge Mata gained some personal knowledge regarding the likely crowd size that was not obtained from nor shared with the parties or counsel. Dude, your client was freaking the fuck out, seeing that her ex-boyfriend, who she has a restraining order against, which is really fucking unnecessary, by the way, was going to be there, and she was fearful. Okay? And the story gained a lot of public interest. Like you were saying here, the media picked it up. International media was covering this story, per your words, earlier in this document. Okay? And you're saying that she somehow secretly gained personal knowledge regarding the crowd size. Like, no. Anyone with a shred of common sense who knows that a celebrity is involved in this case, this bizarre ass case where your client's like lying about having immaculate twins left and right. Okay, anybody could deduce like come up with the rational thought that like there's going to be a lot of people who want to see this. Okay, that's not secret. It's common sense. So you're an asshole for saying that. Don't be an asshole, man. You can do better than that. I know you can. T3, yes, Jingers, thanks for telling the judge the case is so strong that two popular YouTubers and public with very different views agree on this case. That tells you something. Correct. Dave and Megan do seem to have like pretty different views. And I also have pretty different views from everyone sometimes. So, like, you know what? This is not a... It's not a left or right thing. Chris, that was the allegation. I do not, myself, I do not speak on that thing. I don't speak on David's past. I think that I'm interested in this case and what he has to say on this case and why he's wrong about this case. I personally, just my line is I will not cross over into David's personal life. I'm not interested in what he's done in the past. We've all made mistakes. Granted, not that kind of mistake, but I'm just not... I'm just not getting into that, but you're not wrong. That was an accusation, or he was arrested for that. And I think that he was not convicted, if I'm correct, but I don't really know because I'm not really getting into it too much. Class of 83 was also there. Not 100 plus people I was there. Yep, that's right. This was a total exaggeration. All right. Shortly before trial began, I became aware that Mr. Woodnick intended to call a witness named Mike Maricini. Mr. Maricini is an ex-boyfriend of Laura, so we all know that because of what you tweeted. The pair dated for approximately 2 years while living in San Francisco. During the relationship, Laura claimed Mr. Maricini violently assaulted her, causing a traumatic brain injury that eventually resulted in Laura developing epilepsy. Was it a good idea to put this in this filing because your client has some inconsistent stories about that. I think you should have left that one out, dude. Based on this abuse, based on this fabrication, Laura sought and obtained a domestic violence restraining order from the San Francisco County Superior Court, a copy of which is attached here to as Exhibit A. That order, later renewed, remains valid and in effect as of today. And that is a fucking tragedy in our legal system because Laura is full of shit. That's my opinion. I'm allowed to express my opinion. I don't say it to her. I don't want to say it to her. I don't bother her. She doesn't bother me. I'm allowed to express my opinion. My opinion is that Laura Owens is full of shit. Michael Maricini never abused her, and that it is a tragedy that somebody like David Gingras is able to exploit this and continue to hurt Mike with these fraudulent allegations. Christine Norris, does he seem to repeat the same information over and over? Yes. All right. On June 9th, Clayton posted a video on his Instagram page standing next to Mr. Maricini. See, y'all are like all over this shit, right? And then you're like, we didn't know how many people were coming. Bullshit, you didn't. You can't tell me you're like watching everything and pulling everything up and like diabolically thinking about how to frame everything. And then you're just like, oh, I didn't know many people were coming to the trial. Like, fuck that. That's stupid. Okay. In this video, Clayton suggested Mr. Maricini intended to appear at the trial in this matter, despite the RVO issued against him. Okay. Well, he also had a valid subpoena. I notice you haven't mentioned that yet. Valid subpoena. On the morning of June 10th, Laura informed me that she saw Mr. Maricini in the courthouse with Clayton and Mr. Woodnick. No shit. He was subpoenaed. Based on this, Laura told me she was too terrified. Fuck off. Laura told me she was too terrified to participate in the trial, and she told me she intended to leave unless the DVRO was enforced. Having no other available option, fuck that, man. Fuck that. I immediately contacted court security and asked him to enforce the California court's order by removing Mr. Maricini from the facility. Superior Court security officers informed me they did not believe they had the authority to enforce the order because they did not. And they suggested the only option was to call 911 and ask Phoenix PD to enforce the order. Based on that suggestion, I called 911, explained the situation, and asked for officers to enforce the order. You knew he was under subpoena. After a few minutes, Phoenix police responded. They reviewed the California court's order, and I explained to them that pursuant to federal law, the Violence Against Women Act, they were required to enforce the California court's order as written. I provided the officers with a copy of the specific provisions of VEWA, which my client has exploited relentlessly despite never actually having really been abused. Sorry. Got carried away there. That was my opinion. My bad. I provided the officers with a copy of the specific provisions of VEWA, which made interstate enforcement of the order mandatory. Why do I feel like you're leaving something out? Why do you feel like you're leaving something out? Was there maybe a subpoena? Was there a subpoena? I feel like there was. Okay. And I directed their attention to the specific language of the order shown here that required the order to be enforced in all 50 states. This restraining order meets all full faith and credit requirements of the VEWA upon notice of the restrained person. This court has jurisdiction of the parties in the subject matter. The restrained person has been or will be afforded notice and a timely opportunity to be heard as provided by the laws of this jurisdiction. This order is valid and entitled to enforcement in each jurisdiction throughout the 50 states of the United States, the District of Columbia, and all tribal lands, and all U.S. territories, commonwealths, and possessions, and shall be enforced as if it were an order of that jurisdiction. Okay. Where's the rest of the order? We're going to read it because it's in the exhibits. Okay. I also explained that by traveling from California to Arizona for the purpose of violating the order, Mr. Maricini committed a federal crime. Mr. Maricini was compliant with a subpoena, you dickhead. I'm not reading that. Despite this, Phoenix police indicated they believed they had no choice but to defer to Judge Mata on this issue. That's appropriate. As a result, immediately prior to the start of trial, I asked Judge Mata on the record to enforce the California court's order by removing Mr. Maricini from the courtroom. As she had done with substantially every other request, Judge Mata denied my request without any explanation. No, she told you her previous ruling would stand. She has previously ruled on the issue. You're lying. As a result, Laura was forced to sit in court just feet away from Mr. Maricini. First of all, no. Mike was sitting somewhere behind me, and we were on the opposite side of the room. Shut up. As a result, Laura was forced to sit in the court just feet away from Mr. Maricini, which caused her to nearly become overwhelmed by fear, panic, and anxiety. That's probably why she was talking and laughing, smiling with you the whole time. Is that it? Is it because she was so afraid? Yikes. Yikes, dude. Your client was just fine. Maybe a little bummed she didn't get her way. Just my opinion, guys. Just my opinion. What an asshole. At the conclusion, I informed Judge Mata I was leaving the country, celebrate my mother's 80th birthday, left June 10th, remained until the 28th. Okay. The majority of this time was spent on a cruise ship in the Mediterranean with my family. During that time, my internet access was extremely limited. The ship's Wi-Fi connection was so slow that I was unable to view videos posted on any medium. Dude! A lot of that vacation, he was tweeting at people. Maybe not on the boat, but dude. While I was on vacation, Laura contacted me and told me about some extremely disturbing information being shared on social media by Dave Neal and Megan Fox. Specifically, Mr. Neal and Miss Fox appeared in several live-streamed and other videos in which they claimed Judge Mata's father, Harry L. Howe, was present in the overflow room during the trial, and they claimed Mr. Howe spoke with several of Clayton's supporters during and after the trial, proclaiming, "I'm here for the shit show." Is that what the father said, or is that what a rando said? Because we're all randos, right? We're all rando JFC members. Did a rando say that, or did you hear your dad say that? Who said that? Because I heard you like to wear wet socks in the courtroom. But who said that? Was it you? Or was it me? Guess we'll never know. Another individual claimed Judge Mata's father sat with him and expressed that he was here for the circus. Cool. He had to sit somewhere. And since nobody was there to support your clients, you consider everyone else to be part of the JFC crew. And he had to sit down next to someone. I guess technically he was sitting with them. He was, in fact, allowed to sit next to other human beings in a public space. The injustice! I can see why you're so upset. Laura assembled... God, this shit. Okay, hang on. I don't know why he put this on his channel. Like, she already posted on hers, but okay, sure. Jesus Christ, dude. This is... Okay. It weren't for the purpose of violating the order, it was the purpose of testifying under subpoena. But you notice he never says that, right? Okay. Let's go back to the doc. Oh, shit, I gotta go all the way back down to this. Hang on. This thing is so weird. All right. Nope, not that. Okay. Laura assembled excerpts of some of these videos, which are available for viewing here. A CD containing these videos is also lodged herewith. As unusual as this may be, the mere fact Judge Mata's father attended the trial, if true, is not the primary concern. The concern is that, according to comments from Dave Neal, Megan Fox, and others appearing on video with them, Mr. Howe stated Judge Mata discussed the facts of this case with him prior to trial. Okay. Where the fuck is your proof? One such specific statement was made by a person named Hava Derby, who speaks between 00 or like midnight, is it? No, I get it. The beginning and 40 in the above video compliment. Okay, I see. Okay. In her remarks, Ms. Derby claims that she spoke with Judge Mata's father at or immediately after the trial. Ms. Derby stated that Mr. Howe was carrying papers with him, which, based on her comments, may have been Laura's request for findings of facts and conclusions of law. I'm sorry, are those publicly available documents? Maybe. Man had paper. Fuck off. Okay. Julie told me just, Dad, you have got to read this, and printed out a copy for him. Okay. Where is your proof, sir? In the course of making these remarks, Miss Derby also made statements which appeared to imply that Judge Mata told her father that she intended to rule in favor of Clayton before the case was tried. Okay. That's your interpretation of a rumor, asshole. How would you feel if, like, your client turned on you after this and then the other lawyer or somebody involved in the case started interpreting things that your client said about you? Like, you really need to be more careful with this shit, because this is an official court filing. This isn't your Twitter account. This is a court document. The discussion of that point is briefly and not entirely clear, but my belief is based on Miss Derby's claim Mr. Howe whipped out papers that Julie printed them for him, and then she mentions Laura's request for finding of fact and conclusions of law, finally asking, did anyone see those were denied prior to trial? What is also extremely disturbing is that in the video compilation, upon hearing remarks regarding Judge Mata and her father, Dave Neal laughingly commented, to paraphrase, "Hold on, we don't need a mistrial." Yep, that was a joke. Joke. The specific comment from Mr. Neal appeared between 40 and 1 minute in the above video compilation. I understood those remarks from Dave Neal as a signal to the person speaking that they should not disclose further information regarding comments they claim to have received from Judge Mata's father, because he believed they would expose judicial misconduct and bias on Judge Mata's part, requiring a new trial if those facts were exposed. Okay. Well, you know how some girl on the East Coast said she had hooked up with Clayton and he cheated on Susie, but he had proof that he was in Arizona the whole time or whatever? She was lying, intentionally or not. So, I don't know. I could walk up to somebody and say I'm Judge Mata's fucking lesbian sister. Like, that doesn't make it true, but a stranger's not going to know that. How do we know that? So, how do you know? Are you sure? Did you see it? Did you hear it directly? Or are you spreading rumors in a court filing? T3, roll the tape. I will. Just a minute. Okay. God, it's been 2.5 hours, guys. I did not expect this to take so long. Okay. Despite these allegations, my personal view is that Clayton's followers are generally not honest or reliable. Fuck off. Because you don't know the answer to the question or you pretend to be potentially obtuse does not mean somebody's being dishonest. And I consider the possibility the claims made regarding Judge Mata's father may be fabricated, either in whole or in part. Wow. How noble of you, sir. My hero. Given how serious the issues were, I did not believe I could ethically make a formal accusation of judicial, of judicial impropriety without taking some reasonable steps to verify the truth of what happened. Okay. In an effort to ascertain the truth, I sent an email to Judge Mata's division in which I raised concerns regarding Judge Mata's father and the alleged statements made by Dave Neal and Megan Fox. At that time, I had not yet seen Miss Derby's remarks. A true and correct copy of this email is attached here to as Exhibit B. In this email, while noting the highly unusual circumstances, I asked Judge Mata to promptly provide a response to the allegations regarding her father. I further explained that if these allegations were true, I believe they may support a change of judge for cause. A few hours later, I received an email response from Judge Mata's division stating, to the extent that either party wishes to bring a matter to the court's attention, the court respectfully asks that you file the appropriate motion. Is that news to you or anyone? Like, what? Other than this brief response, Judge Mata did not admit or deny the allegations concerning her father. Okay. About 14 hours later, on the morning of June 18th, I received the court's post-trial ruling on the merits, a copy of which is attached here to as Exhibit D. After reviewing the June 18th decision, which found in favor of Clayton as to virtually all issues, Laura and I immediately noticed something truly shocking. The rule contained findings that were not based on any evidence at trial. Instead, those findings were clearly copied from posts on social media. Were they your posts? Or were they comments under your posts, David? It's a real concern. Specifically, and to cite just one obvious example, and then we're talking about Dr. Dean's and the Planned Parenthood on Sunday thing again. I'm not going to harp on that again. I'm not doing that. This is like, oh my God, so repetitive, dude. Okay, no time during her brief testimony did she or anyone else ever address the question of Planned Parenthood being open on Sundays, blah, blah, blah. Okay, as noted above, during the course of my involvement in this matter, I have published a small number of comments, approximately 15... a small number of comments. Dude. Are we going to pretend these weren't novels? Honestly, man. No. As noted above, the JFC Twitter account has posted nearly 3,500 tweets about this case, and the number of other posts on social media is certainly in the tens or hundreds of thousands, if not millions. Millions. Stop flattering yourself, bro. This is ridiculous. God damn it, dude. So it was like Clayton's a minor celebrity, but then it was like Clayton was the star of The Bachelor, this big huge program, and now it's millions of people might be commenting, and shut the fuck up. Just shut up. As limited as my online involvement in this case has been, I believe Judge Mata conducted her own independent research into the facts of this case, and that this involved her reviewing comments posted on my website or other social media pages. Your website and other social media pages were part of the exhibits included in the court filings. First, throughout this case, and repeatedly at trial, Clayton's counsel, Greg Woodnick, vociferously complained to Judge Mata about the fact that I was making public statements about this case via my website and Twitter. And Mr. Woodnick specifically provided copies of articles I wrote and posted on gingerslaw.com about this case. Okay, let's be very specific here. If you had just been like generally talking about something, like at the request of your client, like that's one thing, but you were insulting, you were making stuff up, you were offending the client, you were offending the judge, you were offending the opposing parties, you were accusing them of being corrupt. Like, this is not normal. This is not normal behavior. Dude. I posted up this case. Mr. Okay. I found Mr. Woodnick's complaints in this regard confusing because the information and comments I posted about this case were not improper or in any way. And because Clayton and his supporters, including Mr. Woodnick, had also posted public comments online about this case suggesting that Mr. Woodnick fully understood I had a right to inform the public of Laura's side of the story. Guys, where's Greg's blog? I want to read it. What? Greg doesn't have a blog? It's almost like this guy's full of shit. You have a right to inform the public of Laura's side of the story at your client's request, yes, but you don't have a right to be an asshole with impunity. Like, people are allowed to complain about that. You're not just informing the public of Laura's side of the story. You are slandering a fuck ton of people. And you're calling people a cult and all kinds of shit. Like, let's not pretend you were just telling her side of the story. Let's not pretend you were just giving the facts. You were being a douche. Own it. Based on what I know now, I believe that by pointing to comments on my website, Mr. Woodnick was not actually concerned about the contents of those posts. Believe me, man, everyone was concerned. Instead, I believe he was suggesting or hinting to Judge Mata that she should go online and perform an ex parte review of my site. And I believe that is exactly what she did. Well, the site, the blog posts, were included in the exhibits. She didn't have to go to your website. They were included. That belief is based on the fact that immediately after Laura finished testifying at trial, literally later that same day, anonymous supporters of Clayton began posting comments on my website and also on social media asserting, no, we're not, I'm not doing the Planned Parenthood thing again. We have already talked this to death. If you have nothing else to go on, then you have nothing else to go on, but I'm not reading that again. Okay. For these reasons, I have grounds to believe, and I do believe that on account of bias, prejudice, or other interests the judge currently assigned to this matter, Honorable Julie A. Mata is unable to act fairly and impartially, and she is unable to provide petitioner Laura Owens with a fair trial, including a fair retrial, which Miss Owens is concurrently requesting. Sorry. Okay. Sure. All right. Here is the restraining order against Mike. Okay. It's pretty basic. 5 years. Okay. Firm name, Cooperative Restraining Order Clinic. This is the renewed order. Does anybody have a copy of the initial one? I have a thought, but I'm not going to say it right now. If anyone has a copy of the original one, please DM or email me. Okay. Okay. Sorry, guys. I'm just trying to see if there's any sort of like exception written in here. Okay. So no guns or ammunitions, right? Okay. It's about firearms, animals, custody, property control, debt payment, property restraints. Okay. Spousal supports, home devices, debt payments, insurance, lawyers, fees and costs, blah, 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 blah. Batterer intervention program. That was not checked. Interesting. Okay. Okay. And this is like the excerpt from Vewa that he had put in his video before. Let's see. If you do not obey this order, and it's talking about firearms and all that shit. Okay. Even if the protected person invites or consents to contact with the restrained person, the orders remain in effect and must be enforced. I wonder if that's why she was asking to talk to Mike. That's why she wanted David to get her in touch with Mike. Probably. the protected person cannot be arrested for inviting or consenting to contact with a restrained person. That's exactly what she wanted. The orders can be changed only by another court order. Okay. Conflicting orders. Maybe so here. Okay. Yeah, I don't think that's going to answer my question. That's okay though. I'll just ask Omer. This was his email to Judge Mata's division. Writing to raise an urgent issue, recent social media claims. Bring this to the court's attention. Request a response from Judge Mata. In short, Ms. Owens has informed me the following. Judge Mata's father was personally present in trial, held this matter of Monday, June 10th. After the trial, several individuals, supporters of Mr. ECHARD, claimed to have discussed the case with Judge Mata's father. According to these individuals, Judge Mata's father claimed the judge shared information with him about the case and made comments indicating Judge Mata intended to make adverse rulings against Ms. Owens before trial. Obviously, if these allegations are true, they raise extremely serious concerns. Okay. Ms. Owens has reason to believe the allegations regarding Judge Mata's father are true, blah, blah, blah. So, like, we're lying all the time, per Laura, and we're getting it wrong all the time except for now, right? Just, I want to be clear on that. Before proceeding, as unusual as this may be, I'm respectfully asking Judge Mata to respond directly and explain whether these allegations are true. Okay, so you know that that's not the avenue you're supposed to go through, but you're mad that they wanted you to go through the proper channels. Okay. Fully understand the unusual nature of this message, and as noted above, I understand the allegations may be entirely false. I understand the allegations may be entirely false, and yet, here you are talking as if they are proven to be true, without a doubt. So here is again like where I'm back to like I think that a lot of what he says and does is at his client's request. Ms. Owens has asked me to move forward with an immediate notice of change of judge for cause unless the court confirms the above allegations are false. I hope this will not be necessary given the significant disruptions may cause, but I am ethically obligated to take all appropriate steps to protect Ms. Owens' rights, and I intend to do so. So a lot of this stuff, I feel like it comes from her, right? But he could have walked out at any time, like Lexi, like Corey, and he didn't. Okay. For that reason, I respectfully request a response from the court to the issues raised above by 5 p.m. Arizona time tomorrow, June 18th. Okay, so he sent this, and he did not send it through the proper channel, and then they were like, oh, wow, we sent this, and then the judge put in a ruling, coincidence. Well, dude, you didn't contact her through the proper channels. Like, what are you going to do? Okay. And the court responded, to the extent that either party wishes to bring a matter to the court's attention, the court respectfully asks that you file the appropriate motion. Okay. I don't see anything wrong with that, dude. Okay, what is this? I think, yeah, this is the ruling. And then everything after this is the transcript from court. So we're done reading like what we needed to read here. Let's if you guys want to see the video he was referencing. So this is Laura's compilation of like stuff she's watched on stream. And like I said, keep in mind that she's like watched long ass streams, like all kind of streams, not just Dave and Megan, but people who have barely like, like smaller YouTubers and stuff like that. Like she's watching like a hawk, and then they're making claims like we didn't know there was going to be such a big crowd and stuff like that, as if she hasn't like gathered every single piece of information about everyone who's going to be there. Okay. So keep that in mind when you're watching this. Hold on, let me just make sure he hasn't. Interesting. Oh, it's unlisted. Okay.
Mata's dad in the parking lot afterwards.
Oh, hang on.
And I asked him, like, well, what did you
Let me know if
think?
you can hear
He's
it.
like, I got to show
Or
you
if you can't.
something. So he whips me papers in his hand. And did anybody, I haven't been online really today, but did anybody, I saw kind of briefly that it was denied, this request for findings of fact and conclusions of law and proposed findings. Did she
wasn't denied.
That was not denied. Okay. So anyway, did anybody get a copy of this? He was saying, Julie told me this is just, you dad, you got to read this, and printed out a copy for me.
It's up by Long and Company.
Yeah, Judge Mata's dad was in the court with us.
Judge Mata's dad
was in the court with
No
in
way.
the side room where we were. Judge Mata's dad was sitting there.
She did fantastic.
I said, Harry, that's really nice. You want to be here to support your daughter? He said, oh, no, I've been hearing about this. I'm here for the circus.
Hold on, we don't need a mistrial.
Yeah.
Well, I mean, we could get him some scones.
Yeah, scones.
Okay, so no, I've been hearing about this. He's there not because his daughter's the judge, but because he's been hearing about it. That doesn't support your claim.
We just heard. There you go. Hey, that's I'm sure he was, he was probably a judge. I feel like it runs in the family. Oh, I'm sure, yeah. Sure. And Judge Mata.
Okay.
I
Okay, I didn't quite catch what she was saying there. I'm going to turn my volume up and see if I can get that. Hold on.
Oh, I'm sure, yeah.
I was sitting right next to him. Something, trying to think of what he could say.
Sure.
Huh.
And Judge Mata.
Yeah, guys, I can't catch a lot of that, unfortunately. Okay.
She's such a nice lady. And finding out, did you meet her dad in the overflow room?
I was at the first intermission at the 10-minute break. It was the first time I had heard that he was in there. And then I knew which one he was, but I never spoke to him, no.
I think it's so cute that her dad was there watching this. Like, how fun for him.
Yeah.
His daughter's involved in this, like, high-profile Like, I bet they never considered that could happen in a family court case where there's, like, an ABC bachelor and there's, all this crap in the media van.
Okay, so what I'm hearing here is that this case was kind of a big deal. Like something you wouldn't see every day. So, again, this is not helping their point.
And breadsticks and salad in the parking lot. It was so funny.
And scones.
And cold brew.
When I told you, and I think I told the audience this too, that I was sure that the clerk here and all the people who work here were very aware of this case. Remember when I was like, I'm sure that they are talking about it every time a motion comes in? Well, guess what? I went up to the clerk's desk to get the video footage that they do from the court. And she was looking at me funny, and I'm filling out the form, and she goes, I know who you are.
The infamous.
She goes, I know who you are. I said, you do? She goes, I'm not supposed to say that.
Whoa.
And then a police officer now.
So what we learned from the last bit there was that a person who works a job watches YouTube in their free time. Cool. So, who fucking cares? Andrea Ellerby, it's not even actually submitted, is it? I think I saw somewhere that it was actually submitted, that it was on the docket, but I'm not positive. Like, this came off of Twitter, but I believe that it has actually been filed. Unless we're talking about different things. T3, why is Gingras quoting Megan saying shit show if lady said circus? Because it fits their narrative better. That's the only reason. All right. Does anybody have anything they had a question about or they wanted to bring up? Next stream I do will probably be a little more like last night's, where we're talking more about like psych hospitalization and court ordered psych evals and stuff like that in the context of this case, and like why it's not appropriate, talking about different misconceptions and why I feel like this person would be best served with the jail sentence, that kind of thing. But this we were just reading over this document and it took 3 fucking hours. So yeah. Andrea, yes, I believe they did file it. The financial docs. Lauren, I love your sense of humor and how straightforward your comments are. Most of all, I admire your integrity and respect you showed all here in the chat. Your laugh is contagious. Thank you, Debbie. I appreciate you. I get a little carried away sometimes. Like, I don't know. I try to be like cordial. I try not to be like overly offensive for no reason at all. But sometimes like they'll write something in these filings that's so dumb that I'm just kind of like, you're an asshole. Like it just comes out. So I really try though. I really try to be, I try to at least think back afterwards that like, how could I have been more objective there? How could I have done better with that? And what can I do next time to kind of control my reactions a little bit more? But it's very hard. So, Sabine Simone, the I'm a real judge now just grinds my gears in a huge way. That was the stupidest thing. Lila Smith, Lauren likes to speak to pathological lying. I mean, we could talk about that. We could talk about that. And on the, like I said, the next stream is going to be like the one last night where we talk about stuff like that. So we'll table that for now, but please do remind me, and I'd be happy to. All right, guys. I'm going to hit the end button right now. You're going to be redirected to our friend Brad, IT Goatee. He is doing a dramatic reading right now. Please let him know that Lethal Lauren 904 sent you and give him your love. Hit a like on his video for me, please. I will be there in the comments with you guys if you want to listen and hang out and talk back and forth with Brad. So, yeah, I'll be chatting with you guys there. Okay. Thank you for sticking around. I will see you next time.